15 and 16. But my senior Mr. Surajit Doctor is not in station, my lord. That may kindly come up on 21st of May, my lord.
Learned Counsel Mr. S. Doctor is out of station.
Out of station.
List the matter. Have it
21st.
informed the other side? No.
My lord, there is no any other thing.
List the matter on T.
Now, please, your lordship.
Yes.
Lordship, I beg to mention item number 34, lordship.
Mm.
Lordship, I have a concern from the other side.
Lordship, I am for the petitioners in the matter. Lordship, we would like for an objection to be noted. They've taken multiple dates for filing of the affidavit in opposition.
Lordship, here I am for respondent
Item
1 to
number 36.
34. I am for respondent 1 to 4. Respondent 1 to 4. Lordship, I am praying for here to file an objections against the said condemnation. At the same time, the respondent who is taking steps in this case, he is residing in Bangalore, Lordship. So we pray for some time so that he come forward and
Learned
for the-
Counsel Mr.
essay Bhakhtiar.
Lordship, a
34.
last chance
Okay,
may be noted.
Okay. S. A. Bhakhtiar for the respondent number 124 has prayed for adjournment. Learned Counsel Miss.
Lordship,
What is your name?
B. Agarwala,
B. Agarwal on behalf of Learned Counsel Mr.
SP Roy.
SP Roy representing the appellant has raised serious objections stating that several adjournments have been procured by the respondents. Full stop for the interest of justice. This the matter positively for
If a date may
I-
be fixed, Lordship.
filing their objection,
Filing up against the said condemnation, Lordship.
filing their objection against the condemnation petition on 4 June.
Lordship, 4 June will be difficult for, okay, the occasion of Eid is there, Lordship, after any date after 13th of June, Lordship.
16 June.
Much obliged. Much obliged.
May I please, Lordship?
Mm,
I would like to mention item number 5, Lordship.
mm,
I'm for the respondent number 1 and 2.
Mm.
I have taken consent from the other side, Lordship. Kindly matter may be adjourned for the day.
Learned
That I am
Counsel,
appearing, I am appearing for the petitioner. The only thing is the interim order may be continued.
Learned Counsel Miss
Lordship.
I.
Al Islam.
Al Islam.
Lordship, a date may be fixed.
With the consent of the other side has prayed for adjournment, list the matter on data. 5th of June is fine.
I would like.
Interim to be continued, madam.
Interim order shall remain in force till then. Item number 5 only.
I'll let him know.
Yes.
Obliged.
Wait, please, your lordship. I beg to mention in regard to item number 39. Lordship, there is a talk of compromise going on with the respondent one. Kindly fix the matter after 3 weeks, your lordship,
Learned Counsel Mr.
as the
As
for the
Datta.
appellant.
Has submitted that there is every possibility that this matter may be settled amicably. Learned Counsel Mr. N. Debnath is present for the insurer. Is present.
Respondent, on behalf of the claimant, respondent number 1, 2, and 3.
Is present on behalf of respondent number 1, 2, and 3. List the matter on
After 3 weeks. your
after 3 weeks.
Have you observed?
Or you
Much.
can place it on local alert also if any date has been fixed.
14 June.
14 June. Okay, should I place it?
Okay, your lord.
List this matter before the local alert to be scheduled to be held on 14/6/2025.
Much obliged.
May I please, your lordship? Lordship, I beg to mention item number 7. Lordship, may kindly allow me to withdraw this petition.
Learned Counsel Mr.
M. Ahmed.
M. Ahmed has paid for withdrawal of this application. Learned Additional PP Mr. D.P. Goswami is present. Petition is dismissed on withdrawal.
Similar prayer with regard to item number 11, lordship.
लिख दिए 7 and 11.
7 and 11. Highly opposed.
Item number 1.
May I please, your Lordship? Lordship, I beg to mention item number 1.
Mm.
My senior counsel, Mr. H.R. Sodori is late in court number 19. So matter kindly pass over for the time being. Mas open.
May I please, your lordship? Before I go ahead to the FIR, my lord, which is in page 11, my lord, I'd like to take you for a moment to page number 22, my lord. while perusing the CD, my lord, including ours, my lord, this is a second bail application, my lord, page number 22, my lord, and paragraph 5, my lord, in regards to the injury, my lord. This is for the first time my lord has perused. My lord has perused the series for the second time, my lord, which my lord will find at page 25, my lord. There are co-accused, my lord, who has been taken into custody. Out of 6, my lord, 3 has been taken into custody, my lord. And while perusing the CD, my lord, these were the submissions by the learned PPs, my lord, and court observations, my lord. And page number 25, paragraph 5 again, my lord. Paragraph 4, I beg your pardon, my lord. Paragraph 4. The injuries is simple in nature, my lord. And now my lord can come to the page number 11 is the FIR, my lord. And the both occasions, my lord, out of 6 accused, 3 has been preferred regular bail application because of taking their custody, my lord. And court has come to the conclusion, my lord, the injuries, even though the injuries is serious, my lord, but simple in nature, my lord. With that background, my lord can peruse page number 11 for a moment, my lord. Out of 6 accused, the 3 have been taken into custody and they have been already enlarged on bail, my lord. We are accused number.
We'll need the CD. We'll need the CD. Why we have not granted bail? Though injuries were simple. We'll need the CD.
Against this petition knowledge.
And I think this person is the main one who has cut. Will definitely will consider a bail petition. Call for the CD along with the medical legal report of the injured person, list the matter on. 27.
Any date before that is possible, my lord, dear.
Yes, possible.
I'm deeply obliged. I'm deeply obliged.
Please, your lordship, my lord, this is a revision petition, my lord. We have filed, my lord, against an order that has been, by which, my lord, our temporary injunction has been rejected, my lord. And thereafter, we went for an appeal, my lord. That has also been rejected, my lord, upholding the order, my lord. And against that 2 orders, my lord, I am before your lordship, my lord. So I will take your lordship, firstly to page number 34, the suit, what I have filed, my lord. What has happened, my lord, the background is that, my lord, in the northern side of the petitioner's land, my lord, there was a village path, my lord. So constructions for some construction of the road has been, my lord, sanctioned by the government, my lord. So, my lord, what they have done, my lord, in order to widen the road, my lord, they have broken down my boundary wall, my lord. Despite I know about that, my lord, they are going to break, my lord. We have gone to the circle office. Government, my lord, yes. Circle office, my lord, yes. So thereafter, my lord, they have done on the count that I have encroached, my lord. So, my lord, we went to the, my lord, to file a suit, my lord. And suit is basically for declaration that the plaintiff is the owner, my lord, and for confirmation of possession, my lord. And my lord, my lord, not to encroach the plaintiff private land, my lord. Now we will take your lordship to the schedule, my lord. Schedule lordship will find it page 35, my lord.
Page 35.
Page 35, my lord. So page 34, my lord. Schedule 1 is the, my lord, is a land which the petitioners and along with others they are owning, my lord. So schedule 1, lordship will find that my land in Dag number, my lord, old is 384 and new is 408. The schedule 3rd line, my lord.
Page 34.
Page 34, my lord.
Your land.
Schedule 1, my lord, our Dag, my lord, the land in our Dag, my lord. That is Dag number 3rd line in the schedule, my lord. Lordship will find 3 Dags, my lord. Old Dag number 384, new Dag number is 408, my lord. This is 1 Dag. Then and down below, my lord, the new Dag number 406 and 405, my lord. So lordship
New
is
Dag number 406.
and then down below 405, my lord. Old Dag number, new Dag. I will rely on the new Dag, my lord. So 405, 406, and 408 are the 3 Dags, my lord, which I am owning, my lord. And this is our private land, Miadi land, my lord. And schedule 2, my lord, we have schedule 2 is a part of the schedule 1 land, my lord, where the boundary wall, mentioning the boundary wall, my lord. So, my lord, what has happened, my lord, thereafter, my lord, lordship may kindly come to the sketch map. I will just, it will make the things more clear, my lord. Page 37, my lord.
Yes.
Yeah, Lordship may kindly see page 30, the sketch map, my lord. Lordship may see, my lord, in the middle and in the first box, my lord, square box, in the middle, small village path. Lordship has seen, and Lordship has seen the dark number, my lord, is 306, my lord. This is more important, my lord. Yes, 306, my lord. And Lordship has seen our dark, my lord. It is there, my lord, 405, 406, and 408. Lordship has seen, my lord, 408, 406, and 405. So, my lord, we own, my lord, 408, 405, and 406, and the village path is dark number 308, my lord. Now, what the stand that the government has taken, my lord, at page 42, Lordship may kindly come to the WS, my lord.
Page 42.
Yes, page 42, my lord.
Page 42, yeah.
Third, then I will just read, my lord. The answering defendant have all the rights to construct and develop a village path over government khas land in Dag number 306. So, my lord, we have not gone for 306. We are only on our land, my lord, 405, 406, and 408. They are saying that the government land is in 306, my lord. 306. Now, my lord, when we have approached, my lord, by way of for temporary injunction under order 39, my lord, this trial court, my lord, below at granted, my lord. Lordship may kindly come to page, my lord, 59, my lord.
Page
This is the order. I will just read the operative part, my lord, page 60, my lord.
Okay. Yes.
Page 60, my lord, I will just read, my lord. Considering the aforesaid situation, Lordship find the second para, my
Yes,
lord.
yes.
Considering the aforesaid situation, this court finds that the action of the OP in the name of the development and particularly for construction of Pakka path in the northern side of the suit land is run towards arbitrariness, and further step, that is start of construction work, will certainly bury the claim of the petitioner forever. The construction of public path over the land of others without determinations of its status or required will certainly a conduct of beyond authority, and the public servant is not supposed to be appointed to act with such manner. It is true that the OP will be appeared and with a good case and good defense, but loss apprehended to be sustained by the petitioner is found apparently in irreparable loss. The material placed before this court reflects that the petitioner have title and possession over the suit land. Hence, prima facie case as well as the balance of convenience is in their favor. The delay in starting the construction may not resulted into some inconvenience to the office, but it is never then a great inconvenience to the petitioner whose legal rights over the property by way of loss forever. In view of the above, prayer for injunction restraining the OP from construction path over the suit land, that is my land, my lord, or over the demolished portions wall of the suit land is hereby allowed until further order. Petitioner sides take steps within 24 hours. So, my lord, that is the interim injunction that has been granted, my lord. But my lord, that order has been, my lord, vacated, my lord. He has vacated, my lord. Why, my lord? Lordship may kindly come to page 67, my lord.
Okay.
Page 67, my lord. I will read the last para, my lord, once. Learned counsel for the petitioner has submitted that the plaintiff homestead is situated adjacent south to the disputed land, which is the road. Previously, the circle officer furnished information to the plaintiff that the land covered by Dag number 306 is the agricultural land under the Mayadi Patta number 60, stood in the name of Abdul Khalik and several other persons as pattadars. Later on, different signs, including the circle officer, stated in the written statement annexed to the copy of the information of land mentioned that the land covered by 306 is an agricultural land and which is a khas land. So they are also confused, my lord, whether it is a khas land or not, because in the record it shows, my lord, that it is land belongs to other persons, and thereafter it has also been stated by the circle officer before the court that it is a khas land. So on that view, my lord, as such, there is a contradictions opinion regarding the circle officer, my lord, praying for temporary injunction till disposal of the main suit. But however, my lord, taking this into consideration, my lord, Lordship may kindly come how it is vacated, my lord. Lordship may kindly come to next page, page 68, my lord, the last paragraph, my lord.
Okay. Yes.
After considering the above, it appears before this court that this suit land over which the plaintiff filed this case is a public road. So that is an absurd finding, my lord, because apparently, my lord, our case is that, my lord, that our land belongs to 405, 406, and 408, my lord. And the land, government khas land is in 306, my lord. So persons who is just northern to that road, my lord, one Akidat Hussain, my lord, he has encroached, my lord, actually, my lord, and thereafter by the order of this honorable court, my lord, no, my lord, they have received the instructions, my lord, and in the instructions it has been found out, my lord, that that area has already been recovered from that person, my lord. That report I will give your lordship. But finding is that, my lord, it appears before this court that this suit landowner, who is a plaintiff, filed this suit, is a public road used for large number of villagers for ingress and egress for their village towards their main road. Due to encroachment of the portion of the road on the part of the plaintiff, the circle officer demolished the boundary wall of the plaintiff to clear the road. As such, it appears that the plaintiff failed to establish prima facie case. So now they have come to a finding, my lord, that we have encroached the part of the road, my lord. But now, my lord, when the instruction has been received by this honorable by the council, my lord, Lakshmi, may kindly see, my lord. The encroachment is done by different person, and it has been already been, my lord, taken back, my lord. Because in the sketch map, the lordship has seen.
This is the final order.
This is the final order, yes, my lord. So what I am praying, my lord,
That
my
interim
suit
order, interim it was.
vacated, my lord, yes.
vacated.
So we wanted, my lord, till disposal of the suit, my lord, that injunction order may be there, my lord. That is what I am praying for, because I am not praying for 306, my lord. I am only praying for 305, my land, my lord, 406, 405, and 408, my lord. And apparently,
And
my lord,
the
if
village part is 306.
306, my lord. And Lakshmi, may kindly see, my lord, these instructions, my lord, that they have received. I will take your lordship to the last line, my lord.
Last line, yes.
Yes. The said area of land was encroached by said Akidat Hussain by constructing Pakka wall. I will read the entire one, my lord. That will clear your lordship. This instruction is received by them, my lord. It is produced before the court. I have received a copy from them, my lord. So now the issue whether that land, my lord, demarcation, actually they ought to have done. They have not done the demarcation, my lord. They have simply came and broken the wall, my lord. But actually the land which they suppose that I have encroached, my lord. Actually it was encroached by the persons who adjacent northern to that road, my lord. That is Akidat Hussain, my lord. And now, my lord, Akidat Hussain, from him already it has been, my lord, taken away, my lord. Taken back, my lord. Lordship, I will read that instruction, my lord. With reference to the subject cited above, this letter under reference, I have to honor to furnish below the information as desired. There, sir, the plaintiff are found under possession of DAG number, that is ourselves, my lord, 408 309 Moja so and so, which is a patta land, Chitta copy enclosed. One Akidat Hussain, son of Azizur Rahman, encroached the land measuring 1400 square feet covered by DAG number 306. So that person has done, my lord. I have not done, my lord. Patta number so and so, so and so, so and so, which was recorded in the name of Abdul Khalik. So it is their dispute, my lord, whether it is land belongs to government or it is of Abdul Khalik. We are not on that. 306 is different issue. But the report says that we are on the 405. We are, my lord. As per the prayer petitions of Mr. Abdurrahman Chaudhary and others, Pattadars legal heirs, so and so, along with an istifanama in favor of the government, restoring the same for making government khas. Photocopy of istifanama enclosed. Requested for clearance of the said DAG, which has been used for village path by the Pattadar and others of that locality. The said area of land was encroached by the said Akidat Hussain by constructing Pakka wall. So actually it is done by them, my lord.
That's all that's
Just a
Pakka wall
just
we have demolished.
Yes, my lord. It is by
That's
Akidat.
Pakka wall. Yeah, no, we have submitted we have filed our written statement clearly, Lordship.
Yes, yes.
Page number 38. It is clear.
38 only says about 306, my lord.
We have demolished the wall which were standing over the government khas land also. Nothing else.
Suitably said, my lord.
Para 5, Lordship. Our written statement.
Okay.
Lordship. That there is no land which has been described and referred to as suitland in the plain. The alleged suitland is described in the plain with imaginary boundaries so as to illegally include land of ports situated over the Gulf Castle and to encroach ports situated over Gulf Castle situated over Dagnam 306. We are
Yes.
concerned about the Dagnam 306. The northern boundary of the alleged suitland, as per the description given in the plain, has been illegally and falsely extended in the alleged description as to the alleged include the grab land of the port situated over Gulf Castle, dark number 306. The quantum of the description of the Ellis land as per environment given in the plane and then in the records does not tally with one another. So no executable order can be passed in this instance suit, Lordship. Lordship 6. The instance suit is not true and correct, Lordship. The plaintiff with alter motive to have to come to this honorable court. The plaintiff has not come to this honorable court with clean hand. The plaintiff has filed this suit for creating obstruction of the development of the blaze port running toward the Gulf Coast land covered by Dagnam 306 lots. And thereby to create suffering for the blazers who have been using the said ports since immemorial and make them suffer the most in the rainy season, Lordship. It is to be mentioned here that land of Dagnam 306 extend to the further south of the previously existing wall by nearby land half feet, and to the further south of the land there is an Anganwadi center which clearly proves that fact that the Elix northern boundary wall not in fact a boundary wall but was constructed illegally over Gulf Castle in Dagnam 306 lot. That was demolished by us. It was over the Gulf Castle that was demolished for the
No,
greater interest of the construction of the
This is a
port.
matter of the suit.
Yes, my lord, we are on injunction, my lord. What we
What
are,
to do now?
yeah,
Lordship,
What?
this is our written statement,
I
Lordship.
know what to do now.
Lordship.
He is saying that that land is his and you are saying that.
what I'm saying, my lord. the
We are
land-
concerned about the Gulf Castle land. We are concerned about the blazers interest. So that the road has been constructed clearly, where blazers can be enjoy the roads. Lordship. That is our concern.
The
I'm
land.
not
No, no,
concerned about-
we are not in their ducts, Lordship. It is false,
He's not-
Lordship.
Not concerned
We
about
are,
the road.
Lordship, see,
But only
this is
one
the Lordship,
building.
once,
What-
for a moment, page number 37, which was annexed by the, by this petitioner, Lordship. It is the trace map. It is the type copy trace map, Lordship.
And lordship was
Where is
saying,
the original, Lordship? I have found out about the, about.
my
this
lord,
case,
their
Lordship. I
instruction,
found
my
out,
lord, this WS was filed in the year 2018, my lord. This is the instruction of 2023, my lord. And apparently it might be they have demarcated and they have found that, my lord, that the area of the land which they have an assumption that I have been
Please.
encroachment, my lord. It is
Lordship.
actually encroached by Akita Hussain, my lord, the person in the
He has-
northern to that, my lord.
He has no.
And
Lucas
already, my
Standi,
lord-
Lordship. He has no Lucas Standi to file this suit. Lordship.
My-
As because of, we are not demolish the wall of his dark number. We are demolish the wall which were standing over the government castle 306, dark number 306. That is so.
I'm
Nothing
not-
else, Lord.
My prayer is on my that in
This-
the guise
where's
of
the- where's the
constructing the
original-
road, they should not take away my paternal land. They have broken my wall.
Petition, revision petition.
My lord,
What is your prayer?
my lord, prayer is only, my lord, lordship may kindly come to my prayer, my lord. I am only saying that in temporary injunction will grant till disposal of the suit, my lord. Disposal of the suit. my lord. Lordship may kindly come to page, my lord. Page 14, my lord. The initial interim order that has been granted, an interim order that has been, I am praying for that prayer, my lord, till disposal, my lord. Restraining the respondent from construction of the proposed village path over the land described in schedule 1, that is my land, my lord, which is covered by DAG number 40.
Suit is at what stage of pendency?
My lord, suit, my lord, is stayed, my lord. This is my suit, my lord. This has been stayed by this court, my lord. Because, my lord, if,
And when it was stayed, it was at which stage?
my lord, it was, my lord, evidence has not started, my lord.
Issues were.
Only advocate commissions was done, my lord. Thereafter, my lord, in framing of issues, probably, my lord, it has not been.
That land was, Amin commissioner went to the suit.
No, my lord, advocate commissions went, my lord, and advocate commission, my lord, I have also annexed the advocate commission, my lord. Lordship may kindly see the advocate commission, my lord, report, my lord. What I, at page, my lord, advocate commission report, page 61, my lord. I am not on 306, my lord. My entire prayer is on my land. In the garb of constructing the road,
Page 61.
61, my lord, is
Will
the
you read
advocate
the
commission
report?
report.
Let
Yes,
us
my lord. Lordship may kindly see, my lord, in space 62 is the my lord, it reflects the persons who were present at that time when this advocate commission was done, my lord. Though the time for the local inspection was fixed as so and so, I along with the learned advocate for the plaintiff, Mr. A.R. Tapadan, reached the suit land at around so and so, my lord. The suit land is situated at so and so, Vanga, and learned counsel for the pleader for the defendant side was not personally present on the suit, but one employee of mainly so and so, Surajit Singh of Badarpur circle officer along with two other staffs were present. So it is in their presence of the parties. Now, Lordship, may I kindly see, my lord, page 60, the operative part, my lord.
Page 60,
63, my lord, next page, my lord.
yes.
Lordship, may see the suit land, that's the third paragraph, my lord. The suit land mentioned in the schedule 1 of the plaint is an homestead land, and the suit land mentioned in schedule 2 of the plaint is an extreme northern boundary land of the suit, is a boundary wall, my lord. Over which the traces of demolished RCC Pakka boundary wall is in existence. As per the identification of the plaintiff, I have found total 34 number of RCC pillar is broken conditions lying over the first and second schedule land of the plaint. I have found number of bamboo bush and betel nut trees standing in the east-west direction just inside the broken boundary wall of the plaintiff. The portions marked B to C and D to E, that is, there is stress map, my lord, is given in the page 66, my lord. So it shows, my lord, the portions marked B to C and D to E in the sketch map issuing bracket indicates the demolished portion of the RCC brick wall, and that is the second scheduled suit land, and the area marked so and so indicates the first scheduled suit land of the plaint. As such, suit land is situated in the southern side of the village path, which is a kacha muddy path running east-west direction, just continuous to the second scheduled land. I have found one Anganwadi center so and so. I have found that the homestead of the plaintiff is situated in the east-west directions within the area of the aforesaid first scheduled land, as shown in the sketch map, and the homestead is made up by the brick wall having CI sheets on its roof. Annexure 30-34 are the photograph of the homestead boundary. Homestead and the western boundary wall of the plaintiff fitted with an RCC pillar gate. Exhibit 35 is the sketch map, not in scale, of the entire suit land and the second land of the plaint. The suit first scheduled land is bounded. The boundary, my lord, lordship, we see on the east. The boundary which has been mentioned here and in the plaint is the same, my lord. East, west, north, south, my lord. And second schedule is this, my lord. Second schedule is Kacha Muddy Path. Homestead is ours, my lord, southern, and east, my lord, Ishaq Hussain Graveyard, and so and so. This is what, my lord, my land, my lord. My lord, I am on, my lord, my Patta land. I am praying injunction on my Patta land that they should not come and construct wall in my Dag number. If they construct in 306, I don't have objection. It's better, my lord, I'll get a road nearby to my land, nearby to my homestead land, my lord. I am on 405, 406, and 408. They are telling about 306, and on the guard of 306, they are trying to, my lord, break my boundary wall and they want to occupy my land, my lord. So what I am till my lord, lordship, since we are in the temporary injunction, my lord, till disposal of the suit, my lord. What I am praying, my lord, since I am not praying for 306, my lord, only my land, my lord. So in temporary injunction that has been granted earlier, previously, my lord, that may be continued till disposal, my lord. It will not prejudice them, my lord. I am in my Dag, and they have demarcated also, my lord. The area earlier in 2000, this suit is of, my lord. If you see the suit, my lord, the suit is of 2018, my lord. And now in 23, my lord, they have come, my lord, saying that already that area has already been taken away, my lord, has been recovered, my lord, evicted. The person has been evicted. Akidat said area of the land was encroached by said Akidat Hussain, my lord. The person just near to the northern to that land, my lord, not by me, my lord. So in that, taking that into situations, my lord, just
That WS was filed earlier today.
yes, my lord, in 2018, my lord. This instruction is 2023 by this court, my lord. They have produced this in the court, my lord. What I am praying, my lord, that temporary injunction be maintained, my lord, till disposal, my lord. That's all, my lord. And it is only related to my Dag, my lord.
This application under advocate commissioner's report.
No, it is both, lordship, schedule 1 and schedule 2.
Schedule 1.
Wall was broken, both the Dag number, both the schedule land, schedule 1 and schedule 2, lord. Not only a schedule 1, lord.
My lord,
He is on schedule 1.
Schedule 1
He
is
is
the
on
entire
schedule-
land, my lord, and schedule 2 is the boundary of that land. It is within that schedule 1,
Clearly
my lord.
stated, lordship, page number 63, lordship, clearly stated. Clearly stated. Paragraph, third paragraph, lordship, paragraph
yes.
3. The suit land mentioned in the schedule 1 of the plain is a homestead land, and the suit land mentioned in the schedule 2 of the plain is the extreme northern boundary and the schedule number 1 over the which traces
Yes.
of demolished RCC Pakka boundary wall existence. As per the identification of the plaintiff, I have found total 30 feet, 34 numbers of RCC pillars in broken condition, laying over the first schedule and second schedule load. Not only first schedule, we have demolished the wall which were standing over the first land. That is clear. That is clear. We, as because of road is very necessary, Lordship, in that particular
Yes,
place.
I am not against road.
Road is
matter. I am not
very
against,
necessary,
I am not against road.
They are,
matter.
they are, they are trying to obstruction the development work, Lordship. How can it be possible, Lordship?
My lord, I am on my dag, my lord. They are saying that 306 is their government land, my lord.
We are only.
And now
only-
they have
only
already,
306, Lordship.
they have already evicted that person from that area and they have already the part is by the Aqidat Hussain, my lord. So what else remains, my lord? That I am not praying for 306, my lord. I am only praying the temporary injunction only on my dag, my lord. Lordship may kindly see schedule 2 at page 35 may kindly be seen, my lord. Lordship may kindly come to page 35, my lord. What I am praying, my lord. Page 35, my schedule 2, my lord. Schedule 2, my lord. Within the area of first schedule land on the northern side of the land above the arcs.
That is what is described in page 63.
Yes, my lord.
Northern side.
Yes, my lord. It is within schedule 1 land. My boundary in my wall, in my schedule 1 land, my lord. That I have only made it as
This
a,
wall-
this is a
this wall-
boundary wall.
These were existent of over both the schedule land, Lordship. Schedule 1 and schedule 2. We are only concerned about the 30, tag number 306. And we had demolished the wall which was standing over the government custom. That is all.
That will be decided in the suit and we are on temporary injunction, my lord.
How can a temporary injunction is granted, Lordship?
And temporary injunction by the miscellaneous, if you go by the appeal or appellate order also, my lord, it was only because it was rejected because during rainy season people will suffer. That is the reason for which. My lord, people will suffer, it's fine, my lord. But Lordship may kindly see how the interim order has been granted because I am holding the title, right title in. My lord may kindly see, my lord, the order, first interim order. My lord may kindly see page, only page 60, my lord.
Page 60, yes.
Yes, my lord. Lordship may kindly see in the middle, the material placed, my lord, the second paragraph in the middle, my lord. The material placed before this court reflects that the petitioner have title and possession over the suit land. Hence, the prima facie case as well as the balance of convenience is in their favor. I am praying for my dag, my lord, 405, 406, and 408. I am not praying for 306, my lord. Even the injunction will, Lordship will grant only in regard to my dag, my lord, not 306, my lord. I am telling that in the garb of constructing road over 306, they will construct road in my land, my lord. That is what they are trying to do, my lord. And even
Why will they do?
but
Why
they have,
would the government construct
my
road
lord,
over your
they
land
have broken
without
my
acquiring
lord.
the land?
They have broken my boundary wall, my lord, and now they are coming with this instruction saying that land has actually been, my lord, this land has actually been taken, was under this Aqidat Hussain. They have also taken away from him, my lord. So land already, this area has already been recovered, my lord. The instruction is very much clear, my lord.
And the second part of the page number 60, Lordship.
Page
My learned pen have already read out, Lordship.
Yes.
But next part. Please read till convenience in their favor. And next, Lordship, middle of the portion of the page. The delay of starting the construction work may be resulted into some inconvenience to the opposite, but it is never then a great inconvenience to the petitioner, Lordship.
Whose legal right over?
Legal rights over the property is in the way of the lost favor.
Forever.
In view of the above, the pair of the injunction restraining the opposite party from the construction of the port over the suit land or over the demolished boundary wall of the suit land is hereby allowed until further order. Petitioner side is to take step within 24 hours. Lordship, this is clearly stated that the boundary wall should have been demolished for the construction of the road. And this road was constructed by the PWD department. Here the Eastern Council or PWD department also here, Lordship. They have stated.
Yes, what do you have to say?
We are only executing at this. The cycle officer is the one. They have carried out the eviction process. We are just executing agency to develop that. So definitely we are supporting.
My lord. Suit land is, my lord, is not 306, my lord. They can construct in 306, there is no harm, my lord. Now they have already,
Construct on 306.
yes, my lord. Not my land, my lord.
We are on 306, Lordship. Nothing else, Lordship. We are on 306.
Court has
Lordship.
granted on 306.
And it is clearly,
Suit land, my lord. And subsequent, my lord, on the welfare of the people,
We have the,
record is there.
we have the record.
Yes, my lord, is received, my lord.
Okay.
What I am praying, my lord, temporary injunction till disposal of the suit, my lord, that no restraint from construction on my scheduled land.
no,
Yes.
over the dock number 306, no instruction should be granted.
Time in the evening.
Yes, my lord, my lord.
I'll have to ponder over it.
Yes, my lord.
If I pass the order without you all, then will it be okay? Whether the
Well,
order is in your favor or without your favor?
My lord, no problem, my lord. Because lordship may take into consideration this part, my lord. The instruction,
Lordship,
because that reflects
My-
everything, my lord.
Definitely,
my humble prayer is that, Lordship,
both will be, I think, suffer irreparable loss.
Yes,
Both
my
the
lord.
parties.
Balance, my lord.
Yes.
Yes, my lord.
If I pass any erroneous order,
Yes, my lord.
both the parties will suffer irreparable
Yes, yes,
loss.
yes, my lord.
See, one is for a path of the villagers, which you are
I'm
saying.
also on that, my lord.
it
I'm
is
also
not
on that.
my land, then
Yes.
he's saying that the part of the villagers is your.
Very important, my lord, yes. But
So
not on
I'll
my
have
land,
to
my lord.
Scrutinize the papers.
Yes, my lord. Lordship may kindly see, because I have also annexed here, my lord, the relevant documents,
Because
my
you
lord.
are saying that this is not, and he is saying that this
No,
is.
my lord, what I am trying to point out, my lord, because the suit land is, my lord, my dag, my lord,
Understood.
yes. And they are saying 306. Now they have come and they have demolished, my lord, the boundary wall. I went to the court, my lord, the court has temporarily granted interim injunction, my lord. Thereafter, it was vacated only for the reason that it is required for the ingress of the people, and due to
Villagers.
rainy season, people have difficulty. I also agree with that, my lord. What I am saying that on the garb of constructing road on 306, my lord, they are taking away my private land.
Government will not do that.
No,
yes, Lordship.
now,
Government, if government wants to construct road, they'll acquire the land.
yes, my lord. Now, what has happened, my lord? Recently, my lord, when I approached this honorable court, my lord, that instruction that they have received, my lord, initially the demarcation was not done, my lord. Now, my lord, what they have done with the instruction of 2023, my lord, they come up, my lord, saying that yes, the land which was already.
Now it's 2025 and he's insisting that this is the land, their land. Instruction has come on 2023 and this is 2025.
Yes, my lord.
Now he has turned around and he's saying that this is
But,
my
but
land.
the area of the land encroached by the said Akida Hussain by constructing Pakka wall. It is this area which they wanted, my lord. That should be the warden, my lord. That has been 306 was lying with
Was
him,
there
my lord.
any order from this court to obtain instructions?
No, they have received instruction, my
We have
lord.
received that insight. We are not concerned about the who have constructed the wall. We are concerning about the wall was standing over the golf first lane, Lordship. Now my humble prayer, Lordship, over the, in terms of dock number 306, no any temporary injunction should be granted by this honorable court, Lordship. Only terms of
My
dock
lord,
number
in
306.
Lordship,
See,
what
all the formalities were observed. See, this is the case with the government. So all the formalities were observed. Injunction ex parte was granted or after hearing both.
my lord, if your lordship peruse the order, my lord, the first order, my lord.
It's actually ex parte, should not be, ought not to be.
Lord.
No, it is against the government, my lord. So definitely, my lord, some pleader will be there, my lord. Government pleader will be there, my lord.
First order.
Yes, at page 59, my lord. Lordship may kindly see the third paragraph, my lord. As per the mandate of the section 82 CPC, a notice served upon the land government
So this
pleader.
order is also correct.
Yes, my lord.
So now let's see
Yes, my lord.
where I can help you out.
Yes,
I'll try to.
what I am praying, my lord, my only prayer is on my scheduled land. Actually, in a suit also I have told about my private land. In injunction that is in temporary granted, that was also on my land. They are on 306, the different land. I am not on that, my lord. So what I am praying, my lord, since my entire suit will become infructuous if they go on constructing over my land. So I am only for my protection, my lord. I am saying that my injunction only to restraining them to construct over my land, my lord. Suit
So
land,
you
suit land.
want me to set aside this order and upheld the other order?
No, what I am
Set aside the civil
There are two orders, my lord, vacating
that,
order.
Second order and upheld the first order.
No, yes, my lord. The second order, my lord, this court initially ad interim order, lordship may kindly come to page 59, my lord. This is the ad interim order, my lord, granted, my lord.
Yes.
Now, my lord, interim order granted, my lord, is in presence of pleader, my lord, a government pleader, my lord. Secondly, my lord, it was vacated subsequently, my lord, at page 60. Lordship may kindly come to page 87, my lord.
Please read the prayer portion. I read that order.
Yes, yes.
Both the orders.
Yes,
I
yes,
read,
yes.
So you read
Lordship,
the-
lordship,
your
lordship.
prayer portion.
Yes, I will read the
What
prayer
is your-
portion. Prayer portion at page 14, my lord. My first prayer, my lord. Restraining the respondent from constructing the proposed village path over the land described in Schedule 1, which is covered by DAG number, my lord, 408, 406, 405 of Waterland so-and-so, having Khotianama under so-and-so district so till disposal of the suit. Artful TS number, so before pending before the Munsif number 2, Karimganj, Assam, my lord. So that is my first prayer, my lord. My land, my lord, not on 306, my lord. And secondly, my lord, to set
But,
aside and
this
quash.
is Revision petition, no?
Yes, revision, my lord. Yes, civil revision, my lord.
So how should I pass an injunction order in this petition?
Yes, my lord, in this petition, my lord. Because miscellaneous appeal, my lord, that has been, my lord, not dismissed, my lord. So I am praying the second prayer, set aside and quash the impugn judgment or order passed in miscellaneous appeal by the learned district judge Karimganj, as well as the impugn order passed in miscellaneous case number 49. That is the final, my lord, order in the injunction case, my lord. So these two order, my lord, I am praying for, my lord, setting aside and, my lord, upholding the, my lord, the previous order, first order, my lord, whereby, my lord, restraining that construction to be done in my land, my lord, fruit land, my lord. I am not praying. In my prayer also nowhere I have said about 306, my lord.
No, but they are saying that,
So if at all, my lord,
that,
306,
boundaries have been wrongfully mentioned or wrongly mentioned.
no, my lord, my
That
boundary,
is
my
what
lord,
they are saying.
what I am telling, my lord, I am on,
306, he is not concerned about the DAG number, pattern number, but
yes.
according to him,
Now they, by these,
the
my lord,
boundaries have been
by
misquoted.
this instruction, it is clear now, my lord. By this instruction of 2023, it is clear.
But again, he is in 2025,
But he is-
he is not agreeing with the 2023.
But this is the latest instruction what they have received, my lord. He is arguing on my petition, my lord, no doubt. But actually, this is the instruction of the government, my lord.
You want to say something?
Lordship. No, we are
He
concerned
has
about the
pointed.
306, Lordship. We are concerned about the 306.
But he is saying 306 is not the land where the wall has come.
No.
306 is not his land.
Yes. I'm
Lordship,
not making my land.
order dated 25/4/2018,
Hmm.
page 15. 15.
306 is, according to him, 306 is not his land.
It's not my land.
It was land of somebody else and which has been vacated and taken over.
This was the government khas land acquired by someone, Lordship. Illegally encroached by someone,
Maybe Atik.
which was
Not by article, but different, some different person, it is mentioned, my lord. Actually, it was, instead of Istefanama has been given over for that land to the
we
government.
are not concerned about who have illegally encroached the government khas land. There are existing boundary wall over the government khas land, which was demolished by us, Lordship, after very properly verified.
So suit
So
will
we-
decide, my lord. Regarding, my
approve
lord,
the
boundary
petition.
wall, the suit will decide, my lord. What I am on was only on temporary injunction, my lord.
Both the parties will be at heavy loss.
Yes,
Irreparable
Lordship.
loss.
Lordship,
my lord.
Lordship.
If if your land is allowed to be encroached by the government.
Yes,
not encroached by the
yes, my
government,
lord.
taken
So
over by the government.
that is why, my lord, my anxiety is, my lord, I specifically mentioned my land, DAG number 306. I cannot construct boundary wall, my
It does
lord.
not happen. If government wants to construct road, then
Yes.
acquire the land
This is a
formally
village path, my
under
lord.
the law.
Yes, under the law, they have to acquire, my lord. But if lordship may kindly see what actually, my lord, lordship may kindly see one part, my lord. This is, my lord may kindly come to page 68. The reason, my lord, why it has been broken, my lord. Lordship may kindly see, my lord. Kindly come to page 68 once, my lord. The village, my lord, situation is also, my lord. There's a many groups is there, my lord. Lordship may kindly see. Learned kindly for the opposite party private firm submitted that there is conflict between the plaintiff on the one side and villagers of 2-3 villagers and the government on the other side regarding encroachment of public road by the plaintiff. Such encroachment creates serious traffic disturbance to the general public. So actually there is, my lord, they want to break the boundary wall, my lord. That is the reason, my lord. At the relevant point, because of this groupism and all that, my lord. And subsequently, it was found out, my lord, that land doesn't, I am not occupying, my lord, it is occupied by Aqidat, and he has been taken away from, he has been evicted from that area, my lord. I am on my land, my lord, 405 is a private land, my lord, my Miadi land, my lord. I am on suit land, my lord. I am not on 306. 306 is not my scheduled land, my lord.
So what is your prayer then? Final prayer?
Final prayer, my lord, I am praying, my lord, restraining the respondent from constructing village path on my suit land, my lord. My lord, may restraining the respondent from constructing proposed village path in Schedule 1 land, my lord, in Schedule 1 land, which is covered by DAG number 405, 406, and 408.
Schedule 1 land, no?
Schedule 1 land, my lord.
Okay.
Schedule 1 land till disposal of the suit, my lord. That is my prayer, my lord. And suit land, my lord, Schedule 1 land doesn't include, my lord, the DAG number which they have mentioned, 306, my lord. If at all they will demarcate if they find, my lord, 306, if I have encroached, my lord, the ultimate finality of the suit is this, my lord. Court will decide. We are only on interim injunction, my lord. And my lord, the second prayer is, my lord, to set aside these two orders, my lord. Lordship would find that two orders, my lord, at page.
One.
Two orders. Initially, my lord, injunction has been granted.
Yes.
My lord, injunction has been granted, then steps has been taken, my lord. And thereafter, while deciding that miscase, my lord, order 39 rule 1A, finally it was vacated, my lord. So against that injunction or vacating of that injunction order, my lord, again we have approached, my lord, the district judge, my lord, by way of a miscellaneous appeal, my lord.
Okay.
That miscellaneous appeal also, my lord, was dismissed, my lord, on the count that people will suffer because of rainy season, my lord. But this is not my case, my lord. My case is, my lord, we also know people, we will also enjoy that land, my lord, that road, my lord, but not in the garb of constructing road on 306, you will take my patta land, my lord. I am only on my scheduled land, my lord. That is what, my lord, my prayer, my lord. So restraining to not to construct on my DAG number, not on 306, my lord.
Maybe substantial portion may be encroached by the petitioner, maybe, lordship.
My lord, maybe cannot be a reason, my lord, for
There are
temporary injunction,
68
my lord.
page number
This is
68
the reason for which the
for a-
injunction has been
for a
granted,
moment,
my lord.
lordship. Page number 68 for
decide.
a moment. In the injunction petition, our government advocate have submitted that.
Yes, my lord. It is in presence of both the parties, my lord.
Yes. 68 lordship for a moment, lordship. Just learned government pleader submitted that the suit pot is being used by the local people of the village since long of the ingress and egress from the
Yes.
homestead PWD.
Yes.
The lordship, the plaintiff has already encroached a substantial portion of the suit pot.
My lord, I have constructed a boundary wall.
This is clear.
I have constructed my boundary wall in the year 2000. my lord. After 18 years, they have come, my lord. Lordship may kindly see my statement at page 25. Lordship may kindly see, my lord. Page 25, my lord. Once, my lord. The fourth paragraph, my lord. Page 25, my lord. It is not that I have constructed on day one, my lord. It was constructed, my lord, in the year 2000, January 2000, my lord. Lordship may kindly page 25, para 4, my lord. Page 25, para 4.
Page 25, para 4.
Para 4.
So you have been occupying that land
My lord,
since
I have
2002.
constructed a
Yes.
boundary wall in the year 2000, my lord. Till 2018, my lord, they are
Yes.
silent, my lord. Is it, my lord, it is.
He has been occupied this land
Yes.
since 2000 lords.
So that when you have constructed, it was khas land.
No, my lord, this is my land, my lord. May kindly see, my lord. The first part, the first part of
Yes,
January.
that is khas land.
Lord, my lord, he is saying now after 18 years, my lord. I have constructed on my land, my lord.
Problem is
I have
arises after
constructed
18
in
years.
2000, my lord.
Page
And
25.
yes, my lord, page 25, para 4, my lord. If at all, my lord, it has been considered the government has, then the people would have objected, my lord. They are enjoying from last 18 years over that path, my lord. Now they have saying that it has been encroached. In fact, it has been encroached by Aqidat, my lord, Hussain, my lord. As per the instruction, this is the correct one, my lord. That instructions, my lord, may kindly be noted, my lord.
25 where?
Para 4, my lord. Lordship may kindly see the first party, in the first part of January 2000, the plaintiff number 1 to 6, including the defendant number 9, for their privacy and safety of their homestead as well as their houses, constructed the boundary wall on the western side of the homestead portion in the rough sketch shown so and so, so and so.
Okay.
My lord. Lordship will pass out. But I'm praying only injunction on my suit land, my lord. On my dag, my lord, not on 306,
I
my
will
lord.
check everything.
Yes, my lord, my lord. Lords. And the instructions may kindly be taken into consideration, my lord. The instruction, my lord, 23, my lord, is very relevant, my lord.
Yes, sir.
Yes, my lord. Oblige, my lord.
Oblige.
And in this case, there was a temporary interim order was there, my lord, is operating.
What in the,
Interim order status quo, my lord,
Hmm.
and stay of the proceeding is
In
there,
this
my lord.
case?
Yes, in this case, my lord.
okay.
The
okay.
first order, my lord. The
Well-
order of my lord.
I think last order is also we have.
Yes, my
interim
lord.
order shall
Is continue,
so
my lord.
there's
Right,
no
right,
problem.
right, my lord.
For that order, Lordship,
Oblige,
construction
Mala.
of the road was halt, Lordship.
Construction of the road.
Lordship.
Stall.
This is the very
My lord,
great situation.
construction,
Because,
my
because the
lord,
rainy season is coming, Lordship.
my lord,
That's why
may
all the
kindly say, my
villagers
lord,
will
they are,
suffer.
they are saying their dag is 306.
Yes.
My suit is on
We
405,
are-
406. Why they have stayed, my lord? Why they have,
We are still ready to construct a road over the land of the government khas land, the dark number 306.
Definitely, you'll construct the road over the government first land, not
Yes.
over his.
not, my lord. Yes, my lord.
He'll not
Yes,
construct the government
they-
construct the road.
yes.
We are
Now, my lord, in 23, they have.
clearly verified,
My lord.
clearly verified.
Acquiring of. course.
Yes, my lord. My lord, in now 23, they have come up with that instruction saying that Akidat has, my lord, was evicted. He has been encroaching that land.
Concerned authority have clearly verified, thereafter demolish the wall. Oblige.
Oblige, my lord.
Time na pala yung argument board so we can let. Department and secretary. Position to be that is. My divided.
Item 4. Item number 4.
May I please your lordship?
Yes.
Lordship, in here, my lord, the petitioners are the original plaintiffs in the main title suit, my lords, which is pending for disposal. The petitioners have filed an application under Order 26, Rule 9 of the CPC, which came to be rejected by the learned trial court, my lord. And that rejection order is put under challenge in this petition. Now, lordship may kindly come to the impugn order, which starts at page number 34, my lord. The operative portion your lordship will find at page number 35. That is the observation of the learned trial court lordship. From the second paragraph, my lord, I'm reading. At the outset, it is pertinent to mention that the object of Order 26, Rule 9 of the CPC is to elucidate any matter in dispute. In other words, in any suit where there is a just and proper cause for elucidating any matter in dispute as the case may be, the court may appoint commissioner. However, the court would not appoint a commissioner in mechanical manner without considering the need for appointment of commissioner, nor shall it appoint a commissioner merely because a party asks for it. In the present case, perusal of the case record reveals that the instant matter is still at the stage of PW evidence and the trial of the instant case is yet to commence. Both the parties are yet to lead their evidences. Therefore, considering the stage of the instant matter as well as keeping in view the purpose of local investigation under Order 26, Rule 9 of CPC to obtain such evidence which from its peculiar nature can only be had on the spot, which with a view to elucidate any point which is left doubtful on the evidence produced before the court. I am not inclined to allow the prayer of the opposite party defendant. It is the plaintiff who had filed this application, so it is by mistake written as opposite party. Now, my lord, the factual position is that, lordship, the petitioners are claiming
Hmm.
that the defendants have constructed, the respondents have constructed a pakka boundary wall over the land of the petitioner, which is covered by DAG number 155. Now, as per the contention raised in the written statement by the defendant's lordship, the pakka boundary wall was constructed over the land which is covered by DAG number 156. Both the DAGs are adjacent lands, lordship. And to ascertain whether the pakka boundary wall is constructed over the land covered by DAG number 155 or 156, to ascertain that aspect, the petitioners have made this application for appointment of a Amin commission.
Okay.
And that application has been rejected, my lord. Now, in my humble submission, my lord, the Order 26 Rule 9 is not a stage-centric provision, my lord. It can be directed at any stage of the proceeding, whether before or after commencement of the trial. And since particularly, my lord, in cases where the dispute is relating to any boundary dispute or encroachment, this case is also a case of encroachment and there is a boundary dispute. In those kind of cases, my lord, Amin commissioner can be appointed under.
CPC to department.
In those kind of cases, my lord, Amin commissioner can be appointed under the Order 26 Rule 9
Then
CPC,
we-
my lord. Yes, and this is my humble submission, my lord. And in
To say?
My lord, I am representing defendant, respondent number 1 and 7.
Yes, yes.
My lord, I would submit, my lord, the prayer has been wrongly rejected, my lord. The impugned order was correct because, my lord, Order 26, Rule 9. When the court feels that sufficient evidence has not laid before the court and there are some query to be clarified, then only Amin commission will be appointed, my lord. My lord, here is a case where evidence has not yet been started. That's what the order says. My lord, it is his case that I have encroached into his land. It is he who has to prove it. My lord, he cannot put the court to gather evidence by 26, Order 26, Rule 9, my lord. My lord, court will definitely, that is what Order 26, Rule 9 says. My lord, if some query, some doubt is there in the mind of the court, then court can appoint Amin commission. My lord, when the doubt will be there, only when that both the parties will lay evidence to the pleadings, my lord. So in my submission, my lord, this impugned order has been rightly passed, my lord.
my lord, here the subject matter, the land, we are not claiming the report on nature of possession, my lord. To identify for the identification of the subject matter, my lord, it can be allowed, my lord. And since it is a, my lord, case of encroachment, lordship, and they have denied, they are claiming that the boundary wall is constructed over the land which is covered under 156, my lord. Only this point is to be clarified, is to be ascertained by the commissioner, my lord.
Just a moment, which point to be clarified? Land, dark
wait.
number?
With DAG number 1, my lord, DAG number 155, which is our land, and the defendants have constructed the pakka boundary wall in our land, which is a part of a portion of land, 6
Okay,
lesser
only
land.
This
It is,
much has to be clarified.
yes, this much has to be clarified.
Portion
Whether
of land where a defendant has
Yes.
constructed the boundary wall.
constructed the boundary
Illegally
over
bound-
the land which is covered under 155 or 156, my lord. And lord,
My lord, may I clarify, my lord? My learned friend in his plaint says that I have encroached into 6 lessers of land out of his 2 kathas something land
That much I understood.
under DAG number 155. The defendant in their written statement says our land is under 156, DAG number 156, and we have 4 kathas, 4 lessers of land. 4 kathas, 18 lessers of land altogether. So out
And you
of
have
the,
constructed your land over
yes,
your,
I say it is our 156 DAG under this, my lord. And disputed portion of land is that 6 lessers.
yes, lordship. That
6
is,
lessers is land. And we said that 6 lessers of land is a part of our 4 kathas, 18 lessers of land, which is under 156. Now, lordship, say under Order 26, Rule 9. May I read this provision?
yes, yes.
it says, in any suit in which the court deems a local investigation to be required, to be requisite or proper for purpose of elucidating any matter in dispute, or of ascertaining the market value of any property or the amount of any profit or damages or annual rent profit, the court may issue a commission to such person as it think fit, directing him to make such investigation and to report thereon to the court, provided that where the state government has made rule as to the provision of the commission. The court will appoint a commission only when there is a
But there
doubt or query in the mind of the court. When it will arise, my lord, when both the parties will lay evidence to that. And if it is 6 lesses of land I have encroached, he has to prove when I have encroached, how I have encroached and all.
Lordship, I'm relying upon
But it
two,
cannot. It will equal.
Lordship, I'm relying upon two judgments of different high courts, Lordship, that may, I'll hand over for convenience. Lordship,
Which
may
one?
kindly take up the first,
First one?
Uh, Lordship, my first one is from the Karnataka High Court, my lord.
Karnataka High Court.
Karnataka High Court.
Yes.
Lordship, may kindly come to the paragraph number 13 of the judgment, page number 4. The next question is, at what stage of the proceeding in a suit the application can lie? As we could easily notice from the provision is not stage centric. Thus, the provision can be invoked either before the commencement of the trial or after. If the application is filed before the commencement of the trial, the court, having regard to the pleadings and records, may allow such application before the commencement of the trial. Now, Lordship may skip this part and kindly come to paragraph 14, my lord. The discretion though lies with the court to appoint the commissioner before the trial or after the trial, the decision must be taken with regard to the possibility of reducing or eliminating the need to record the oral evidence of the witnesses to prove an issue which could be effectively decided with the aid of the report. More often than not, in disputes relating to the existence of pathway, stream, pond, well, or disputes relating to boundary between adjoining holders, encroachment, easement of air and light, construction of building in violation of setback rules, and or relating to the authenticity of a document, signature, thumb impression, to the to name a few by way of illustration. A report secured before the trial may cut short the trial in as much as the party relying upon the report may not examine multiple witnesses to prove the matters covered by the report. The party may simply raise his case based on his evidence and the report. In a given case, the appointment of commissioner before commencement of the trial may facilitate a focused trial. Now, the lordship, in paragraph 21 of these judgments, it is specifically mentioned that having examined the provisions referred to above and given the fact under order 26 of the Code of Civil Procedure is often invoked in the trial court, this court is of the view, broadly speaking, in the following cases, the appointment of a appropriate commissioner as provided under order 26 of the code is desirable. This kind of cases, the dispute relating to the easement of air, light, pathway, road, water house, etc. Number 2, the dispute relating to the boundary enforcement, which is in our case, my lord. So in this kind of cases, my lord, Arming Commission can be appointed, my lord, and the provision does not prescribe any stage, my lord.
It is there.
Yes, lordship. And it would aid in expeditious disposal of the case, my lord. And the defendants will not be prejudiced if this application is allowed, my lord. In any manner, they will not
You
be
see,
prejudiced.
what is that in this, if the court feels, if the court deems fit,
Yes.
so the trial court will decide whether the court deems fit or not. I do not know whether it's required for the trial court.
And moreover, my lord, no liberty is given in the order, my lord, so that if requirement arises at the subsequent stage, we
Yes,
can
I
make
can-
similar application.
I can give the liberty, you can file a similar application. Now the court is not finding it appropriate, so let us see. I can send it back. You can file a fresh application at the appropriate stage. It is not
That can-
stage centric, true enough, but the court doesn't want. And the court at the grassroots level, the court is better
My lord,
place to decide.
if this
whether
application is
this-
allowed,
yeah.
my lord, nobody will be prejudiced, and in fact, it would help in a focused trial, lordship. It would be an handy tool to expedite disposal of the case, my lord.
My lord, idea is
Because
to,
the,
court mechanism may not be used to prove certain things, my lord. When you, yes, my lord, if it is in case of easement, if it is in case of waterways, roads and essential services, it's okay. My lord, under CPC, there are two provisions
No,
where
but it is relating to encroachment also.
encroachment, he has to prove when I have encroached, how I have encroached, my lord.
yes, we have.
My lord,
pleaded-
there are two stages when commission lordship is aware, my lord. If it is so essential, there is a provision under order 13 and rule 7 also where court suo motu can appoint commission. But this is not same under 26(7), my lord. When a commission is appointed, this report is received, my lord, under 26(7), it becomes a part of the evidence, my lord.
Yes, that can
So
be
that may
reported.
not be, my lord. My understanding is a court mechanism may not be moved to gather evidence, my lord. It is his duty to prove his case. It is my duty to prove my case. If after laying the evidences by both the parties, if there is some doubt, then 26(7). Otherwise, court is empowered under 39 rule 7, my lord. That is my understanding, my lord. And the judgments also says the same thing. Yes, my lord, boundary disputes are okay, but boundary may be in connection with easement. Threshold is easement, waterways, airways, and etc. my lord. Essential not to prove, my lord. Otherwise, in so many cases, there are court will
No,
issue
no.
commission only. That is
If
not.
court feels.
If court feels, my lord,
No, court can allow.
court can allow. If yes, my
because
lord,
boundary dispute, court can allow.
court can allow. But primarily, my lord, these evidences are to be laid by the parties, my lord.
Admittedly, this is the discretion of the
See,
learned trial
once
court.
if it's rejected from this court,
Yes,
so then there'll be a problem also. Once it's rejected, so if you want to file a subsequent petition, maybe the court may not feel like allowing also. But okay, you can file a fresh
Yes,
petition.
liberty may be given, my lord. At
Because,
a
my lord,
relevant time, he will file.
this requirement may arise at the subsequent stage also, my lord, because to remove some ambiguity, my lord, the report of the commissioner is necessary, lord. Spot verification is necessary, my lord. Otherwise, my lord,
Let
they
me
are
see the petition first.
my lord.
I'll come back. That original petition has been annexed. no?
Yes, lordship, I have an.
I'll come back and hear. you.
Yes.
Show me your original petition.
My lord. The petition starts at page number, my lord, 18, lord. The plea of encroachment is there in paragraph 5 of the, which is at page number 20, lordship.
This was the petition under order 26 rule 9.
No, this is the plaint and the petition under order 26 rule 9 that
Page 30.
30, my page.
Page 13.
Paragraph 2, that in the suit, the defendants have submitted their written statement stating the fact that Schedule B land, that is the suit land of the plaintiffs, is not the part of the Schedule A land. Rather, the Schedule B land is the part of land measuring 4 Katha 4 Lesa covered by DAG number 156, Patta number 12291 in the revenue village so and so. That's why in order to ascertain the subject matter of the suit land, there needs to be appointed the ASO Balizana Revenue Circle as Amin Commissioner to investigate whether the Schedule B land is the part of Schedule A land or not. Schedule B is the 6 letter
I'm
land.
sending it back. You can file a fresh petition at a later stage. Court is not willing, so I'm sending it back
My lord,
with a liberty to.
my lord,
There is another judgment from the Madhya Pradesh High Court. For a moment, if
From who?
Madhya Pradesh High Court, I have already given Lordship.
Yes.
Paragraph 10 may kindly be referred first, my lord. In cases where there is no agreed map between the parties and where question of enforcement is involved, the power under Order 26, Rule 9 can very well be exercised. This specifically held, my lord. And if your lordship may kindly refer paragraph 7, here also, my lord, the first point raised by petitioner is that power under Order 26, Rule 9 cannot be exercised at initial stage of the suit. A plain reading of the said provision shows that it
No,
does
it's
not.
okay, that is
Yes,
correct.
lordship. And the ground of rejection is that only, my lord, that it is at the stage of PW evidence and trial is yet to commence. Therefore, this petition, this application is rejected, my lord. Leave it to your lordship, my lord. If your lordship is not inclined, at least, my lord, liberty is given so that the petitioner may file similar application at the subsequent stage if such requirement arises.
My lord, regarding liberty, I have no problem, my lord. Liberty he may get, my lord. He will make subsequent applications. But what I say, my lord, in the plaint itself, I'll read paragraph 5 and 6 of the plaint at page 20. And what the statement says, our statement. My lord, para 5, that the defendants have started boundary wall on 4/5/2011. Pausing here, my lord, the suit was filed in 2020. By encroaching the plaintiff's land shown in Schedule A in the plain measuring 2 kotha 4 lesses of land, that the encroachment portion of 6 lesses of land upon which the Pakka boundary wall the defendant stands showed separately and so and so so and so. But just after start of the wall, the plaintiffs protested and obstructed, but defendants did not care their protest. Rather, they continuing the wall. Therefore, plaintiffs on the next day filed a petition before SO Goalpara for demarcation of the land between the parties, but no action was taken by the ASO Balizara Circle. Therefore, on 18/1/2014, another petition was filed before the Balizara Circle and the neighboring of the Sidul land, except the defendants have filed no objection, no demarcation of the Sidule land and the land of the defendants, but immediately no action was taken. That on 25/6/19 and on so and so so and so demarcated the land of the plaintiffs and the defendants and other surrounding land. And after demarcation, the revenue department clearly find out that the defendants have built their Pakka boundary wall by encroaching 6 lesses of land of the plaintiff. That the revenue authority, that is the ASO and senior mandals, directed the defendants on the same day, that is on so and so so and so, to remove the Pakka boundary wall from the land of the plaintiff. But in spite the direction of the defendants have not removed the Pakka boundary wall from the Schedule B land and the plaintiffs, and there is no sign of any necessary action on their part. Rather, the defendants have been trying to extend boundary wall in the western side to close the plaintiff's path in the western side of the plaintiff's own land and measuring so and so so and so. This was the allegation in the plaint. There is no document submitted along with the plaint so far as what I have got her. And
Let's not get into that.
yes, my lord. And
No,
kindly
not
see, my
getting
lord. No, why I am saying, my lord, why I am saying what is the response to this in defendants, my lord. That gives the issue that both the parties has to adduce evidence. That is what I am saying, my lord. This is his statement. He has to prove.
Para
My lord.
27.
This is para 5 and 6. Lordship will find our response to this.
No, we'll not get into that.
Yes, my lord. My lord, we,
Because it has been, this order has been passed, everything has been written in the order, correctly describing elaborately passed order. We'll
Yes,
not
sir.
get into that.
yes, my lord, just, my lord,
As it is, I'm sending it back. I'm sending it back.
With liberty.
well, here is a statement why I am wanting to point out, my lord. Here is a statement that defendant number 1 at page 26 in our pleading say, we have taken constructed the boundary wall after taking permission from all the departments, my lord. That is our pleading. My lord,
It's okay.
That
Learned Council, heard Learned Council. Mr.
Zaman.
Zaman
Law.
item number 4, na? Zaman for the petitioner and Learned Council, Mr. P. Hazarika.
T.R. Sharma.
T.R. Sharma.
For 1 and 7.
Number 1 to 7.
No, 1 and 7, my lord.
For
Only
respondent
two
number 1 and 7. What about the others?
But they have filed one affidavit saying that they have taken dusty and last order reflects, my lord, notices that.
Yes. All are family members of dependent number, respondent number 1.
The petitioners, no?
Petitioners. Yes, Lordship. Petitioners.
16.
Uh,
16 petitioners.
yes, Lordship, 16 petition.
The petitioners have filed this application. Number nalage 16 আছে। Any head নাম দিবই। The petitioners have filed this application under Article 227 of the Constitution of India against the order dated 21/7/2023 passed in title suit number 2 of 2020 by the learned Court of Munsif number 1 Gwalpara, rejecting the petition number 794 of 2023 filed by the plaintiffs stroke petitioners under order 26 rule 9 26 to Roman code rule 9 to figure 9 of the Code of Civil Procedure within bracket CPC bracket close, thereby rejecting the prayer to appoint a commissioner to appoint an Amin commissioner to investigate and submit a report. The learned counsel for the respondent has submitted that a recent order has been passed and as the order has been correctly passed, the order is not required to be interfered and set aside. Full stop. The order dated 21/7/2023 in connection with TS number 2 of 2020 is reproduced here in below verbatim. Etu enke colon di play enke di order to gute to thaidiba italics page number over 34 annexure 4 to page number 35 oleke continue hoise. It is submitted on behalf of the petitioner that an order under or that the object that an order under order 26 rule 9 of the CPC is not a stage centric order. First of this order can be passed at any stage. The learned counsel for the petitioner has relied on the decision of the High Court of Judicature of Madhya Pradesh in Anurag Jaiswal versus Collector, Khandwa, KHANDWA and others, wherein it has been observed that
Para 7 and 10.
Para 7 and 10.
7 and 10.
Heady of Periata Dipla, star Dipla, Para 7 to D, Mazot star to D Dipa. Italics of Dipla, that's 10. The learned counsel for the petitioner has also relied on the decision of the High Court of Judicature
Karnataka.
at Karnataka,
Reported in 20.
Kalaburagi bench, in connection with reported in Agoto level, reported in 2018 0 Supreme MP 865. In connection with Sri Sadak Sharappa versus Kumari Vijayalakshmi, reported in 2023 0 Supreme within bracket Karnataka 325 that
Paragraph 13, 14, 20, 21 also relevant.
paragraph 13, 14 or 21. It's true that this is a case relating to a boundary dispute, but the trial court was not uh, the trial court at the initial stage did not deem it appropriate to appoint a commissioner without at that stage, लिखिए, at that stage. So it is also true that any order under order 26 rule 9 of CPC is not a stage centric order, and so such an order can be passed at any stage of the uh, proceeding. As it was the trial court's observation that at that stage, the matter which was pending before the court, the local investigation, any local investigation was not required. To unearth the position of the boundary, disputed boundary of the disputed land, the disputed land or suit land, boundary of the suit land and the area in dispute, full stop. I've also considered the submission that investigation or that trial, that evidence has not yet commenced. Full stop. At this juncture, the impugned order is not set aside. At this juncture, the petition is not allowed to set aside for setting aside the impugned order. However, the petitioner is at liberty to file a fresh petition under order 26 rule 9 of the CPC if at any stage of the proceeding it appears that that an investigation by a local inquiry,
Local.
inquiry,
By Army
local
Commission.
inquiry by an army commissioner is necessary. In support of the evidence of the dispute relating to the suit land.
Yes.
In terms of the above observation, this petition stands disposed of.
Yes.
Obliged, Lordship.
We have the trial court records.
Yes, Lordship. LCR
Send
is
back
there.
the LCR, send back the trial court record.
Obliged.
Give a date, Harry Hall.
Lordship, date needs to be fixed in that case, my lord. If LCR is here, my lord.
Yes, yes. Petitioner, both the parties are directed to appear for the trial court on, shall I fix a date? Or
They will appear.
Lordship will fix a date, my lord. That will be easier.
That can be done.
on liquidate,
Any date in June, my lord.
6th of June.
Obliged.
Okay, 6th of June or
Six.
later,
Yes,
6th of
fine,
June.
my lord, 6th of June.
Obliged.
Lordship, this is an statutory appeal lordship under MPA lordship. We are challenging a quantum lordship. Actually, this is an injury case where it is stated that there are 75% disablement, but there is no material in the evidence of doctor about concerning this. Yes, no.
Lordship, subject to deposition of 75% of the.
Sorry?
Subject to deposition of 75%.
Also, at this stage, we are ready to deposit also 50%.
50% interest.
Sorry? 50% with interest.
That will
In that case, lordship, they may be directed to sign a bond lordship. When they are going to withdraw.
we will punish.
If they we win that, then
Yes, it's. Learned counsel, Mr.
AJ cycle.
AJ Sergey is present for the appellant. Learned counsel, Mr.
M. Talukdar.
M. Talukdar is present for the insurer.
1 and 2.
Or
One and
for
two.
the insurer.
Yes, lordship.
1
For
and
the respondent number 1 and 2. What is your grievance?
Lordship, against 75% disablement lordship,
Uh,
when without any
this,
evidence of
This appeal is referred against the judgment and order dated MSC injury case number 23 of 2019 passed by the learned member MSCT on 20/06/2024.
MSCT Morigaon lordship.
MCT Morigaon.
Oh,
Morigaon.
okay, MSCT Morigaon. I have scrutinized the memo of appeal. It appears that appeal lies against the impugned judgment and order. The appeal is admitted subject to the condition that the appellant deposits 50%
With
of the
interest.
50% of the
Awarded amount.
awarded amount along with interest.
Interest.
Along with interest accrued, full stop. No, comma, subject to the condition that the
Lordship, here, lordship, injured is claimant respondent number 1,
okay,
and he was represented by his wife, claimant respondent number 2.
so she will execute the bond.
2
He is still
maybe
undergoing treatment.
respondent number 2 may be allowed to withdraw the sale.
Okay, subject to the condition that the respondent number 2 allows executes a bond to the satisfaction of the registry of this court.
Lordship, further prayer is there. The respondent 2 will furnish bank details to the registry, and registry may be directed to transfer the same in the bank account of the respondent number 2.
It is also submitted that the respondent number 2 is willing to furnish the bank details before the registry for disbursements of the amount into her bank account.
Lordship.
To her bank
And
account.
registry may be directed to transfer the said amount in the bank account of respondent.
Which may be transferred by the registry
Hmm.
to the respondent number 2 through her bank account.
Lordship.
In her bank account.
In her bank account.
Then we will
Lordship,
raise this matter.
Lordship, LCR has to be called, lordship,
Okay, call for the LCR.
and we will take step on respondent number 3, lordship. Respondent 3 owner of the vehicle will have to take a step, lordship.
Appellant to take steps to issue notice to
Respondent number 3.
respondent number
3.
3. Call for the trial court records.
Lordship, time period maybe mentioned of visiting
Please,
them.
this,
6 weeks, Lordship.
returnable within 6 weeks.
Time.
Regarding Lordship deposit fees,
Deposit date.
praying for short
Oh,
time.
yes. Within
6 weeks,
3 weeks
Lordship.
from today, deposit the amount there, also within 3 weeks from today.
Lordship, that may be 6 weeks.
4 weeks.
Within 4 weeks from today.
Lordship.
Are here returnable to 4 weeks to it.
Lordship,
Please, according-
there is step edition one. Lordship.
State
IA is there, Lordship, 1065 for staying the operation of the.
1065.
Yes.
Okay. Both the parties are represented at both the sides. The appeal is the applicant has preferred an appeal against the judgment and order dated 26/2024 passed by the learned member MACT Morigaon in connection with MAC case number 23 of 2019. Full stop. The appeal has been admitted. Considering the submissions at the bar, the operation of the impugned judgment and order is stayed until further orders. In terms of the above observation, IU stands disposed of. On খেলমিল হলে মোক কাৰেকশ্যন কৰি দিম নহ'লে তাহাঁতক তাৰপৰা সুধি ল'বা
Obliged.
May I please join? My lord, in this case, my lord, I have been in custody since and I'm paying bail now in arrest procedure ground. And also, my lord, your lordships 2 times repeated orders. The trial has not progressed. The trial was in
NDPS case.
NDPS case.
Go for the trial court
Might,
records, go
might.
for the trial court records, scan copies. Scan copies of the trial court records along with the scan copies of the CD. List 21.
24 or 22nd.
Primary details. 26.
Please.
Madam, on last occasion, madam, we have they wanted to file the objection, my lord, here only on the count of length of detention, my lord. And lordship's earlier order, my lord, which was disposed of by this honorable court, that lordship find that is 100, my lord. That order
Page 100.
100, my lord. That order was passed on, my lord, 3/1/2024, my lord. That is around, my lord, 1 year, 4 months, more than 1 year, 4 months back, my lord. And in the meantime, my lord, now, my lord, he is in custody, my lord, around 712 days, my lord. And almost it will be 2 years on next 4th, my lord. And here recovery is 23 kg, my lord, of ganja, my lord. And 2 persons were there, my lord, 1 fled away, my lord. So this present accused, he remained there, my lord. So he was arrested along with 2, my lord, trolley bags, my lord. And from both, my lord, total, it is 23 kg, my lord. And the other person, he is has been shown as an absconder. So, my lord, it has been split up against him, my lord. Now, my lord, here, my lord, there are 9 number of witnesses. And if your lordship, last occasion,
Same person, Gulzaruddin. Gulzaruddin.
yes, Gulzaruddin, 1 person with your lordship. Now here, my lord, by first, my lord, if your lordship kindly have a look at page 68, my lord. There, lordship would find, my lord, on the date fixed, my lord. There no PW, my lord, came, my lord. And thereafter, page 70, my lord. By page 70, my lord, the seizing officer was called as PW1, my lord. Page 70. So, my lord, the defense, my lord, they took the plea because, my lord, seizing officer, my lord, possibly if he is taken later on, my lord, because other witness may be taken up earlier, my lord. That's why, my lord, on one date, my lord, the time was taken, my lord. So he was discharged and to call him again subsequently after.
On one date, you did not.
Yes, my lord. That
That is in page 70.
70, my lord. Yes,
In
my
page
lord.
68.
68 is the first order by which, my lord, no PW came, my lord, before
Okay,
the
okay,
court. 50, yes, that was 5
Right,
4
Lord.
2024 order. 68. Thereafter, again, page 73, my lord. Lordship found that there was no PW came, my lord. Subsequently, on page 75, my lord, on the next date, two PWs came, my lord. Page 75. They were examined, cross-examined, and, my lord, they were discharged.
So how many PWs are examined?
But it will be three because subsequently, if you kindly have a look
Okay.
at page 81, my
Okay,
lord,
3 PWs out of 8.
it's 8, my lord. 9, 9, 9, my lord.
9. Okay.
9. But here, what happened, my lord? Kindly have a look at page because they have to be recalled. Because, my lord, kindly have a look at page 81, my lord. No charges were framed, my lord.
Oh,
That I pointed last occasion, my lord. So when no charges were framed, my lord.
without having charges,
Yes,
they
my
have
lord.
taken evidence.
Yes, my lord, exactly. And defense counsel were asked whether they want to cross-examine the other two. So they stated regarding two, they do not want to cross-examine. Only one they want to cross-examine. That is also apparent from page 82. The same order, my lord. And thereafter also page 84, Lordship find no PW came, my lord. And only page 28, Lordship find, I'm sorry, my page 87, there Lordship find that two witnesses, or one witness came, my lord. I'm sorry, not two, but one, my page.
Where is the order when it was discovered that charges were not framed?
That Lordship find 80, 81, my lord.
Frame, charge frame the PTM. Episode date
Oh,
of
that's it, sir. And on that day itself, my lord, charges were framed, my lord.
Because Nisanta Goswami was there. He is very alert and agile.
Yes, yes, my lord.
Yes, yes, my lord. We have filed our objection, my lord. In this objection, everything has been, dear my lord. They have complied and stated that no notice has been issued to the relative of the accused.
Yeah, taken grounds of arrest.
That, my lord, only length of detention Lordship may consider, my lord, because possibly it will be 2 years, my lord. So we are not on that as of now, my lord. If your Lordship is not satisfied, then we can go into that aspect.
Grounds of arrest.
Otherwise, my lord, it may be recorded. I am not going into that, my lord, as on date, my lord, because
Punishment is up to 10 years. But still it is on 1.5 years, I think.
so
So
What did you want to say on notice?
notice already the family relatives of the accused has been informed by phone. That
Okay.
fine.
Our learned counsel, Mr. H. Chaudhary for the petitioner.
Only one aspect, my lord, Lordship definitely, my lord. They in their objection, my lord, just academic, my lord. They have stated about Antil case, my lord. Not Antil case, my lord.
Okay.
So there they want to say that proposition that
5 years.
436A. So, my lord, 10, my lord, minimum half sentence, he has to be there.
5 years.
Yes, ma'am. But there are other judgments also. It does not limit the power of this honorable court, my lord, to grant bail.
For the petitioner Gulzar Uddin, who has filed his application under section 483 of the Indian Code 2023 with prayer for bail as is behind bars since 4/6/2023, almost 2 years.
Yes, yes.
In connection with NDPS case number 196 of 2023 arising out of so and so PS case under so and so sections. Hard miss
PS Chakraborty,
PS Chakraborty. PS Chakraborty,
SP, yeah. Special
special PP
PRI.
DRI, who has raised serious objection stating that this is a heinous offense and the petitioner is not entitled to bail. An objection, a written objection has also been filed against the bail petition. Full stop. It is submitted that the petitioner was apprehended while he was in conscious possession of 23 kgs of ganja. Full stop. I have considered the submissions at the bar with circumspection. It is submitted on behalf of the petitioner that his right to personal liberty has been curtailed as three, no?
3 minutes.
As only 3 out of 9 witnesses have been examined so far. The culmination of trial indeed appears to be remote. Full stop. It is further submitted that the trial has been procrastinated by the prosecution as well as by the court. It is further submitted that, okay, I'll just mention one line, grounds of arrest were also not communicated to the petitioner in a manner which could be understood by the petitioner. I have considered submissions at the bar. I have considered the submissions at the bar with circumspection. Full stop. Indeed, the petitioner has been behind bars for 712 days and trial has been procrastinated. It appears that culmination of the trial appears to be remote. The merits of this case are not brought to the court as trial is still under progress. Full stop. It is also apparent that the grounds of arrest were not communicated to the petitioner in a manner, petitioner or to his relatives. Full stop. It appears that bail may be granted to the petitioner. The petitioner is hereby enlarged on bail of rupees 1 lakh with 2.
Can you little listen?
One.
Oh, remote area, my lord.
1.
My lord.
With 1 local surety of like amount to the satisfaction of the trial court under the condition that the petitioner shall refrain from such activities with which he shall act. The petitioner shall jurisdiction of the court.
My lord.
He's still in the jurisdiction of the
Yes,
court
yes,
or
ma'am.
outsider.
No,
The petitioner shall not leave the jurisdiction of the court till completion of trial, and the petitioner shall not exercise threats to witnesses or try to influence them on breach of any of the bail conditions. The court is at liberty to immediately cancel the bail granted to the petitioner.
my lord, he's from Lanka. I'm sorry, my lord. So prior permission, my lord, from the court.
To delete till completion of trial.
From Hojai, my lord. And 2 orders, my lord, I'll just show my lord once, my lord, because for clarity, my lord, page 91, my lord. They took time, my lord. Page 91, my lord. 1 witness came, my lord. That's why, my lord.
They will not go for appeal.
And another.
For appeal, then there you show it.
There may be some
I won't-
departmental procedure also.
I won't look into it. If they go for appeal, then you submit over there in the village.
It is on record. That's fine. Apply them.
Get into it.
Only that prior permission, my lord, because he's from Lanka, my lord.
I have deleted.
Much obliged, highly obliged.
I'm gonna charge 6 submitted cases.
Shasi submit is Learned Counsel Ms. S. Nazin is present for the petitioner. Learned Additional PP Mr. D.P. Goswami has submitted that charge has been laid against the petitioner. The petitioner is at liberty to approach the jurisdictional court stroke Laka magistrate and apply for bail which may be considered by the court in accordance with law. Item 3.
May please, your lord. I am the offense under section 22C, my lord. I am behind the bar for last more than 22 months, my lord. And considering the length of detention and my lord ground that non-communication of ground of arrest in a language understood by the accused person, 2 co-accused persons are given bail by the honorable court. 1 order I have annexed, my lord, and another, my lord, last 14 of May, my lord. So my lord, I'm praying for bail on the ground of parity and my lord, non-communication of ground of arrest, my lord, in a language understood by the accused person. my lord. I am behind the bar for last more than 22 months, my lord. On 8/6/2023, I was arrested, my lord. One order I have annexed, my lord. I am behind the bar from 8/6/2023, my lord. Honorable, altogether 4 accused persons were arrested. Out of 4, my lord, 2 are given bail by this honorable court, my lord. One order I have annexed and another, my lord, I have protected.
Here is a charge framed on 12/23, Lordship. And there are 8 PWs out of
12/23.
Lordship. Out of 8 PW, only 1 PW is examined on 18/3/25.
What is the contraband?
Contraband is 300.
My lord,
300 gram
suspected
heroin.
heroin of 300 gram.
300 gram heroin.
Our learned counsel, what is your name?
My lord, name of the accused person, my lord. R. Sharma, my lord.
Our learned counsel, Mr. R. Sama, for the petitioner. Mujibur Rahman,
My lord.
who has
Mujib.
filed his application under section 480 of the PNWS 2023 with prayer for bail as he is behind bars since 12/12/2023 in connection with special NDPS case number 59 of 2023 arising out of so and so PS case under so and so sections. Had Mr. D.P. Goswami learned additional BP Assam. It is submitted on behalf of the petitioner that trial has been procrastinated and the right to his personal liberty has been curtailed. Full stop. Moreover, the grounds of arrest were not communicated to the petitioner in a manner which could be understood by the petitioner, and the petitioner deserves bail on that score alone. Full stop. It is further submitted that 2 co-accused have already been granted bail in connection with the same case, in connection with the arising out of same cause of action in connection with the same case, in connection with BA number 3015. What are the cases?
My lord, 3015, my lord, Javel Hussain. BA number 3015.
BA number 3015 of 2024.
Another, my lord, 1370/2025. Abul
Where
Hussain.
in file order dated 8/4/2025, Jabal Hussain, alias Jabal Hussain was granted bail, and also in connection with BA number where
1370/2025.
where 1370, I don't have that case here.
My lord,
Yeah.
Abul Hasim.
Second to cut it. On the contrary, next the learned edition PP Mr. D.P. Goswami has raised serious objections stating that 300 grams of heroin was alleged to have been transported by the petitioner. Full stop. The petitioner is booked under a heinous offense, and there is every possibility that the petitioner will again repeat the offense if he is enlarged on bail. I have considered the submissions at the bar with circumspection. It is true that the petitioner is booked under a heinous offense, but at the same time, it is also true that the petitioner has been behind bars for more than 22 months, and only 1 out of 8 enlisted witnesses have been examined so far. Most of the culmination of trial indeed appears to be remote. Most of the grounds of arrest were also not communicated to the petitioner in a language, in a manner in a manner to which he could understand the grounds of arrest. As mandated, in compliance with the decision of the Honorable Supreme Court in Bihan Kumar versus State of Haryana and another reported in 2025 within bracket 0 bracket close Supreme SC 283. It appears that bail may be granted to the petitioner. Considering all aspects, the petitioner Mujibur Rahman is enlarged on bail of rupees 1 lakh with 2 local sureties of like amount to the satisfaction of the learned trial court. Under the condition that the petitioner shall appear before the shall not leave the jurisdiction of the court without prior permission to completion of trial. The petitioner shall refrain from such activities with which he is harassed, and the petitioner shall not exercise threats to the witnesses or try to influence them. On breach of any of the bail conditions, the court is at liberty to immediately cancel the bail granted to the petitioner.
Item 12.
Obliged, Lordship. Deeply obliged.
May I please, the lordship? My lord, the regular bail application, my lord, and I had been surseated also, my lord. In under section 22C and 29 of the NDPS Act, my lord. My lordship was pleased to call for the scanned copy of the records, my lord.
Yeah.
My lordship also wanted to verify that during the, my lord, course of arrest, whether the requirement has been followed or not, as the Bihan Kumar and Purakashta is now governing the field, my lord. So that is one aspect of the case, my lord. And secondly, initially, my lord, when the FIR was lodged, my lord, I am not the named accused, my lord, but subsequently during the course of the investigation, my lord, my name had been spelled out by some of the arrested accused persons, my lord, and that's why I had been arrested. And since, my lord, I have been arrested on 8/7/2023, my lord, and till date, my lord, I am behind the bar. My lord, I have to submit fairly before my lord. My lord, I have approached before my lordships twice, my lord. At that relevant period of time, as the my lord, my lord, the trial was not commenced. My lord, that's why my lordship was pleased to reject my bail application at that relevant period of time. In fact, my lord, my instruction is that till date, my lord, a person and accused has not been apprehended by the police, and therefore, my lord, trial has not yet been commenced, my lord. That is my instruction. So, my lord, exactly 2 persons had been surseated. One person has already been enlarged on bail on 8/5/2025, my lord, by another, my lord, honorable coordinate bench of this honorable court, my lord. If my lord, and I am also relying on that judgment, my lord, has been passed. My lord, the principle of parity my lordship may also consider, my lord. Mojibur,
Anything about grounds of arrest?
my lord, similar, same, my lord. The ground of arrest has also not been followed here in this case also, my lord, that Bihan Kumar and Purakashta has been violated. And my lord, in paragraph 6, it has been recorded, my lord. আৰু এটা copy আছে। দাদা, মজিবুৰ ৰহমান।
Yes, sir.
Recovery was made from this petitioner also.
No recovery, my lord.
That petitioner who was enlarged on bail.
Who was Mujibur Rahman was that person.
That
my lord. So
person.
he has been released on bail.
Only basis,
Nothing,
only was the basis of the that's his statement.
Statement.
He was this person, this petitioner was arrested.
arrested, my lord.
And
I have no role, my lord, regarding transaction or selling or purchasing, my lord. I have been just arrested because my name had been spelled out by the.
And charge sheet was submitted on 39/23.
Right.
And there are 10 PWs because one person is not apprehended yet, lordship. That's why trial is not pending yet, lordship. And next date of appearance of 23/5/25.
Under any condition, my lord, strict condition, my lordship may, as the similar person has been enlarged on bail, my lord, of the same case,
Contraband?
my lord.
What is the contraband?
Contraband was
some tablets, Yaba tablets.
Yaba tablet.
My lord. My lord can verify from the FIR, my lord. I have annexed it at page 24, my lord. My lord, the drug suspected to be Yaba tablets is going to deal by 2 persons at Kora area, Mazarkanti, fourth line, my lord. Page 24.
By learned counsel, Mr. A.R.
Yeah, my lord. Only A.R. Bhuyam. My lord.
Not Borbuya.
No, my lord.
For the petitioner Usman Ali, who has filed his application under section 483 of the BNWS 2023 with prayer for bail as is behind bars since 8/7/2023 in connection with
Badarpur PS.
Badarpur PS case number
171.
171 of 20 March.
Special NDPS case number 77 of
Yes, yes,
2023, arising out of so and so PS case under so and so section. It is submitted on behalf of the petitioner that trial has not yet commenced despite submission of charge sheet as one who accused is still absconding. Full stop. It is submitted that uh, the that another co-accused have been enlarged on bail but in connection with BA number 1187 of 2025 while order dated 8/5/2025 in Mujibur Rahman versus State of Assam. The petitioner has prayed for bail on the ground of parity as well as on the ground of prolonged incarceration. Heard Mr. DP Goswami, learned additional PP Assam. Post of the learned additional PP has raised serious objections stating that the petitioner is a history cheater with record of transportation of drugs. Post of the petitioner was arrested on the basis of being involved in transportation of 432 grams of Yaba tablets. And he is not entitled to bail considering the gravity of the offense. I have considered the submissions at the bar with circumspection. It is true that the petitioner is booked under the heinous offense and charge sheet has been laid against him. But at the same time, it is also true that trial has been procrastinated. Full stop. The one co-accused is yet to be arrested and produced for trial. Full stop. 10 PWs, 10 prosecution witnesses are enlisted, and culmination of trial appears to be remote. It is also I have also considered the submission that the grounds of arrest have not been communicated to the petitioner in a manner which the petitioner could understand the grounds for which he was forwarded to custody. Considering all aspects, it appears that bail may be granted to the petitioner. The petitioner is thereby enlarged on bail of rupees 1 lakh with 2 local sureties of like amount to the satisfaction of the learned trial court under the condition that the petitioner shall refrain from such activities with which he is alleged. The petitioner shall not leave the jurisdiction of the court without prior permission till completion of trial, and the petitioner shall not exercise threats to the witnesses or try to influence them on breach of any of the bail conditions. And the court is at liberty to immediately cancel the bail granted to the petitioner.
Well, highly obliged, my lord.
May I please, Lord? Second bill application, my lord. Earlier, lordship was rejected the bail, my lord. The earlier order, my lord.
You have the CD?
Yes, Lord. Okay, FIR at page number 10, my lord. The condition is that the accused person must, my lord, forcefully kidnap the informant, my lord.
Please, your lordship.
Yes.
My lord, answer has been received, my lord. Qualification is fixed for hearing, my lord.
What about the other side?
Okay, last day they have appeared, my lord. 8/5/2025 or 24. Order dated, no?
one L Sharma. Represented by K.K. Bhutto.
Huh?
In the cause list, the name of the council has not been shown. My lord.
Are you are as the
Hemanto Gogoi,
learned counsel, Mr. H. Gogoi?
H. Gogoi.
Your name is in the cause list?
No, my lord.
You are present?
I'm on behalf of S.
S.
Das. S. Das.
On behalf of learned counsel, Mr. S. Das, representing the appellant is present. The learned counsel for the respondent number 2 has appeared on the previous day, i.e. 8/5/2024. But he is not present today. The respondent number, but he is not present today. LCR has received this matter for hearing.
Highly honorable.
Do you want a date? It's an old pending case. Do you want a date?
My lord,
Old pending case, this matter for hearing on date.
kindly fix a date. 5th June. Highly honorable.
Parties are not represented today. The matter was last listed on 15/11/2021 for the interest of justice. List this matter on. On failure of appearance of any of the parties, this unnecessary order may be passed. 19 to zero. Which I want. 20, 21, 22.
Twenty to 20.
Other side is not present.
20? Yes, actually.
একেলগে order কৰি দিম। The appellant is not represented today. You are present for?
Lordship, item number 20, I am for the respondent 1, and 21 and 22, I am for the respondent 1 and 2.
Learned counsel Miss
R. Gogoi.
R. Gogoi is present for respondent number 1 and 1 and respondent number 1 and 2. Office note dated 1, respondent number 1 in item number
20, Lordship.
20. In connection with respondent number 1 and respondent number 1 and 2 in connection with MSA bill number 419 of 2022 and 415 of 2022 respectively. 20 and 21, no?
I'm for a petitioner.
20 and 21.
21 and 22, I am for the 1 and 2.
Oh, 21 and 22 respectively, 20 and 22. Yeah, appellant is not represented legal as a learned counsel, Mr. A.J. Sokia
Lordship,
is present for the appellant.
municipal publication has been made, Lordship, in all the municipal publication has been made, affidavit has been filed, Lordship, in all the cases. Service is complete, Lordship, LCR has also filed.
Office note dated 18/3/2018, no?
Office note dated, Lordship, 16/5/25. Where affidavit has been filed, it is recorded, Lordship.
16/5/2025.
Yes, affidavit is.
Indicates that affidavit of public paper publication of notice upon respondent number 2A, 2B, and 3. No, it has not been filed. Or has been filed. Seen the affidavit that filed by the appellant that notices have been issued to the aforementioned respondents to newspaper publication. It is submitted that service of notice is complete. List the matter for hearing.
Yes, sir.
Did we call for the LCR earlier?
LCI is already there.
List the matter for hearing. You want a date?
After summer vacation, that's it.
Oh, the summer vacation. This is matter for hearing after summer vacation.
Other two cases are also connected closely.
Yes.
21 and 22, both are connected.
Yes.
All the cases.
Item 19.
May I pray, madam? I'm sorry, 18 and 19 minor analogous matter arising out of same accident. Here, service is complete, LCR also received. So can this,
18, 19, we'll take up together.
Yes.
Can I pass orders together in both the
yes,
cases?
yes,
Learned Counsel, Mr.
A Bhattacharya.
A. Bhattacharya is present, present for the appellant, and Learned Counsel, Ms.
MCK, your lordship.
MCK is present.
Respondent number 1.
Only
Sole
full
respondent.
For the sole respondent. We have issued notice, or we have received the LCR, no?
Yes,
Service is complete.
complete.
I'll list this matter for hearing. Do you
On,
want
can
a
it
date?
be on 10th of June, my lord?
10th of June, fine. On 10th of June. All right,
Obliged.
Nice lordship.
has it been admitted?
Yes, admitted.
Because yesterday I dealt with I have given a judgment, matter was not admitted.
No, no,
And
it
it was
is
fit for hearing, I have heard it and then I think it was judged.
admitted, madam. I have checked. Obliged.
Item 23. Item 23.
Division party and non-classes. Parties are not represented for the interest of justice. List this matter down. After 1 week, on failure of appearance of both the parties, the order may be cancelled. Parties are not represent, this matter has come up for, come up after. This matter was last came up on 29/11. It's in.
Item 24.
My lordship, I'm acting on behalf of my senior, Mr. A.R. Borua. We need some time to file objection, Your lordship.
Applicant is not represented today, Learned Counsel, Mr.
MJ Hazarika.
Huh?
MJ Hazarika.
MJ.
MJ Hazarika.
MJ Hazarika is present on behalf of Learned.
Respondent number 2.
Huh?
A.R. Borua.
A.R. Bova, representing the respondent, and has submitted for time to file objection against this application. Is the matter after 1 week?
4 weeks, Your lordship. Must have lordship.
Number 25 and 26.
My lord, this is 2IA, my lord. Both appellant and the respondent has approached this honorable court challenging the judgment and order dated of the single bench. So, my lord, in my case, the notice has not been completed, my lord. He may accept the notice in the cross appeal, my lord, and may come up next Friday for hearing.
I,
In 26, my lord.
What do you mean?
In IA, in item number 26, that is IA number 2164. Food
yes, I
Corporation
number 2164.
2164. 2164 is filed by him and 1448 filed by the Food Corporation of India, my lord.
Both the
In-
parties are represented. IA 2164, both the parties are represented. So
Or today, if he has no objection in continuation of petition, it can be continued in both the cases and the.
Yes, Lordship.
Yes, my lord. Today was.
Dealing may be condemned, Lordship.
both the parties are represented. IA 2164 to liaison, IA learned counsel, Mr. BK Singh, no? BK Singh,
PK Singh, my lord.
or it will be, here you will be the applicant.
Yes, Lordship.
Learned counsel, Mr.
BP Sharma.
BP Sharma, on behalf of learned counsel, Mr.
J. R. Hazarika.
Huh?
R. Hazarika.
Mr. R. Hazarika, representing the appellant is present. The appellant has filed this application under order, under section 5.
Lordship.
Limitation Act. Under section 5 of the Limitation Act 1963, with prayer for condonation of delay of 115 days in passing in preferring the connected appeal. Appeal, no?
Appeal, my lord.
Lordship.
To stop, the applicant is agreed by the judgment and order dated 29, judgment and decree dated 29/10/2022, passed by the learned civil judge Jorhat in money suit number 2 of 2014.
My lord, it is 2014.
Hmm?
Money shoot number 2 of 2014.
2 of 2014. So it is submitted that next slide here. After the judgment and decree, the applicant was advised over mobile phone to prepare an appeal before the Guwahati High Court. And he was requested to collect the judgment from the office. Thereafter, the applicant collected the copies of the judgment and decree. And he acted upon the advice of the engaged counsel, whom he consulted on 11/12/2022. After consultation with his family members, the applicant decided to refer this appeal so delay was owing to the winter vacation followed by the Bihu vacation of this code from 2022 and 16 up to 16/1/2023, and thereafter on 20/01/2023. Full stop. The applicant could not meet, could not consult the engaged counsel stationed at Guwahati. To stop, it is submitted that delay was not intentional. To stop, there is every possibility that the appeal may succeed. To stop, the applicant has shown sufficient grounds. I have heard the learned counsel for the respondent, considering the submissions at the bar, delay of 115 days is hereby condoned, basically to register the connected appeal. In terms of the above objection, the IA stands. Heard learned counsel, Mr. BK Singh, no?
My lord.
For the applicant who has filed this application under
41 Rule 3A. Order 41 rule 3. Extra.
Order 41 Rule 3A of the CPC for continuation of delay of 49 days in preferring the first appeal against the judgment and order dated 29/10/2022 passed by the learned civil judge in money suit number 2 of 2014. Learned counsel Mr.
VP Sharma.
VP Sharma is present on behalf of learned counsel Mr.
R. Hazarika.
R. Hazarika, representing the respondent. Here notice was not issued.
Notice was issued, my lord, but the service was not completed.
Okay. The learned, now you will accept the notice, no?
Lordship, I have received the copy of the petition.
The learned counsel for the respondent has accepted the notice on behalf of the respondents. Full stop. It is submitted that due to the shifting of the regional office of FCI and owing to the technical issues relating to the shifting of the office, there was a resultant delay. Okay. And any other ground in preferring the appeal?
I've taken how the 49 days was happened, my lord, from paragraph 2, my lord. How the file has moved, my lord. It's since it's a PSU, my lord, from paragraph 3.
It is also submitted that as the respondents are PSUs, no?
PSU, my Food Corporation.
As the applicants.
Applicant, my
Applicants are public PSU are under are a unit of PSU. The formalities also resulted in the delay. Most of it is submitted that delay was not intentional and sufficient grounds have been shown. Full stop. It is submitted that there is every possibility that the appeal may succeed. I have considered the submissions at the bar with circumspection. It appears that delay may be condoned. Thereby, the delay of 49 days in preparing the connected appeal is condoned. In terms of the above observation, this application stands disposed of. Registered to register the connected appeal. It was IA 1448. Ematro kuntu dintu dilo 1448. Agotu asale 2164. Item 27.
My lord, any fixed date for the appeal, my lord?
No.
23,
no? 2020.
My lord, I'm sorry to say, your lordship, my item number was 23, your lordship. My lord, service report was waited, your lord. Service report
23.
was waited.
Oh, non-replaced.
My-
You are present now.
my lord.
23.
And interim may kindly be continued. There is interim.
Learned Counsel, Mr.
Aaron.
A. Roman is present for the appellant. Service report on respondents, all the respondents.
Person number 2 and 3 waited.
Respondent number 2 and 3 is awaited. Interim order shall remain in force till the next date of listing. List them matter after 2 weeks.
My lord. Mass of lordship. May I please lordship? I please lordship. In this case, respondent number 1, 3 and 4 has appeared. There is a order of the law, Rajama court also.
Well, 5, 6, 7 so far added here, my lord. In the second appeal, they were not party. They are the daughters of the plaintiff. Appellant here, my lord.
Now I am submitting and making submission. Regarding respondent number 2, lordship, she has died. But her legal heirs are respondent number 3 and 4. So her name may be struck off. Legal heirs are already on record. Yes.
Respondent number
2.
2. Okay.
And regarding respondent number 5, notice has been served. It may be deemed served. She has refused, lordship. And respondent number 7, her name may be struck off. Because she is a legal heirs of the original plaintiff, our sister.
They are not parties in the title suit and title appeal.
They are legal heirs. That's why that they have been in.
In the case, madam, earlier. As pro forma respondents, they have added here. Doctor of the, kindly see your lordship, page 5, madam.
4, 5 and 6.
5, 6 and 7. 5 to 7 are daughters of.
So now he can, he is submitting to strike or respondent.
Yes, yes.
Respondent number 7 was struck.
No,
Only 5 and 6.
Yes, 6 is served. 5 has refused, so it may be deemed served.
Deemed to be served.
And name of
Learned Counsel,
2 may be struck off because.
yes.
expired.
I'll ask you again because I may forget.
Yes.
Learned Counsel, Mr. S.D. Pukester is present for the appellants, and Learned Counsel, Mr. H. Das
Yes,
is
madam. I am
present,
appearing for respondent 1, 3 and 4.
present for the respondent number 1, 3 and 4. It is submitted by the Learned Counsel for the appellant that the legal heirs of respondent number 2 has been impleaded and the respondent number 2 has passed away and her name may be struck off. Full stop. Considering the submission, the name of respondent number 2 is struck off. It is further submitted that respondent number 5 has refused to accept notice. Where is the note? Office note?
Office note dated 6/8. 6/5. 6/5/2020.
Office note dated 6/5/2025 indicates that the respondent number 5 has refused to accept a notice. Post of notice is thereby deemed to be served. The Learned Counsel for the applicant has also submitted that the name of respondent number 7 may be struck off. Full stop. On the submission of the Learned Counsel for the appellant likhi asa na? Learned Counsel for appellant likhi thiki. The name of respondent number 7 is struck off. So now. what is-
6 is completed. LCR is also received. So it may come up for hearing on usual.
Notice
No, not usual course, my lord. The board the court is there, it has been dismissed, my lord. One
no.
date may be given, my lord.
There are 2, lordship, why I am submitting.
In board the court,
He cannot.
title should.
No, he may file early hearing
Title
application.
appeal
He may
dismissed,
file early hearing application. We may
Date
also
may be
file
given,
early.
my lord, thereafter, whatever may be, my lord, if it is not
No, no,
reached.
the-
17 June. my lord.
Notice has been served to respondent number 6. Full stop. LCR is received. List this matter for hearing. When do you want?
17, my lord, June.
17 June.
Lordship, 24 matter. 2024 matter.
In board the court,
There is
my
a
lord.
procedure for it may they may file early hearing application, and there is another RSA also
Let
between
me
the
take
same.
one
It's
chance, my lord.
usual process.
My lord,
You
let
can
me
come
take
up
one
for
chance,
earlier
my
If
lord.
we feel it
Come up
necessary,
earlier
we also
listing.
file early hearing application.
Not, my lord, just come your hearing, my lord. If it is
Early hearing
last
file
order,
for-
my lord, your lordship, my lord, in the usual course, and it will not come, my lord. As board the court already, my lord.
That is the procedure for filing early hearing application.
List this matter for hearing, usual course na lage.
Yes.
All right.
All right.
I'm sorry, Lordship, I missed out item 24, Lordship. I am for the applicant. It is fixed after 4 weeks. My presence may be shown.
Yeah. The learned counsel, Miss R D Chaudhary is present for the.
Hadi Mojumdar,
R D Mozumdar is present for the appellant.
applicant. This is I lordship for delay condonation.
When do you want? We'll change it. When do you
Lordship, let it come next week because the delay can be condoned, service is complete.
want? This is the matter on after 1 week.
Okay. After 1 week, Lordship, I will not be there. Let it be after 4 weeks then. Because next week I'm
You'll be out of station.
out of station. Lordship, let it be after 4 weeks.
Please the matter after 4.
Highly obliged.
May it please, your lordship. Your lordship service is complete in this matter and also LCA received. The matter is,
For hearing,
yes, your,
learned counsel Mr. S. Dutta is present for the appellant. For admission hearing. Petitioner. Oh, it is
For the
not
petition.
admitted.
It is not admitted, my lordship.
Okay, we'll list it for
My lord, may kindly fix a date. If possible.
yes, you are representing everybody.
Both the respondents.
Learned counsel Miss
Jay Sharma on behalf of A. Iqbal.
Jay Sharma is present on behalf of learned counsel Mr. A. Iqbal representing the
Respondents.
respondents. Item number 28,
28.
LCR is received,
yes, sir.
Yes.
ending else. So we'll list it for admission,
Yes.
Admission hearing.
not admitted as yet.
No, yeah.
This matter for admission
My lord, a date may be fixed.
on 9 June.
Obliged.
That's all right.
Item 29.
May I please, your lordship? Your lordship, the transfer matter, your lordship, service is complete, your lordship.
Lordship.
My friend is appearing, your lordship.
I'm appearing for respondent.
Learned counsel Mr.
R.A. Mazumdar.
R.A. Chaudhary is present for the appellant, petitioner and
Pet-
learned counsel Miss
P. Odhikari.
P. Odhikari is present for the respondent. List this matter.
A date may be fixed, your lordship. Any date. Then interim may be continued, your.
Interim order shall remain in force till the next date.
Oblige.
Item number 30. This is matter of 10 June.
Lordship, in this case, my learned friend has required for the respondent claimant.
Respondent
The
one and
appeal may be disposed of at this stage, Lordship, because arising out of the same judgment, Lordship, two appeal was filed. One appeal was filed by the Oriental Insurance Company and one was filed by the New India Insurance Company. The appeal filed by Oriental Insurance Company was allowed, Lordship. Liability was, Lordship, fastened upon the two insurance company 50-50 basis. Against the judgment, Lordship, we filed appeal. They also filed against the quantum award. We also filed against the quantum award. The appeal filed by Oriental Insurance Company has been allowed, Lordship. So, Lordship, it's a covert case, Lordship. The
Two appeals, no?
appeals, MSC appeal number 21 of 2016, Lordship, already disposed of, Lordship.
Oh, 21 of has already been disposed of. Okay.
Lordship.
That has been.
I think out of the same cause of action. So this
Yes, yes.
case is covered.
Yes, sir.
Yes, sir.
Our learned counsel, Mr.
KK Bhatta.
KK Bhatta for the appellant. New India Insurance,
Lordship,
New India Assurance
Assurance Company.
Company Limited. And Learned Counsel Miss P. Borua, Lordship. P. Borua for the respondents.
One and two.
I'm appearing only for 1 and 2.
Respondents number 1 and 2. And Miss Bella Shah.
Yes.
Miss Bella Shah and and Sri Rohan Singh.
Rohan Shah.
Rohan Shah. Now he must be a major, I think.
He must be major.
He must have attained majority. Full stop. This appeal is preferred by the insurer challenging the judgment and order dated 11/8/2015
Lordship,
in connection passed by the learned additional district judge number 3 Kamrup M Guwahati in MSC case number 651 of 2008, which was originally registered as MSC case number 999 of 2007. Okay, is it correct?
651 of 2000.
Was it originally registered as 999 of 2007?
Yes, yes.
Yes, no?
And it's
999 2007.
Mm,
So original
999
was-
9.
It is submitted that the accident the genesis of the case was that on 24/3/2006, this must be their father, no? Husband,
Husband.
the person who died.
Yes, Lordship.
Himanshu Shah
Himanshu Shah.
submitted that Himanshu Shah, husband of respondent number 1, was traveling from Dibrugarh to Guwahati in a Volvo super bus bearing registration number AS01U 5585 as passenger, who stopped suddenly at Nazira Khat, near Inti Line Hotel on NS 37 under Khetri PS. The bus, which was driven with excessive speed and in a very rash and negligent manner, met with an accident with a truck bearing registration number AS01C stroke 7771. Full stop. Himanshu Shah died as a result of the accident. Full stop. The claimants then preferred the claim petition and invite the impugned judgment and order the claimants were awarded a compensation of rupees 50 lakhs 960 5,000,960. Only inclusive of no fault liability with interest at rupees 6% per annum from the date of filing of the claim petition till payment to the OP number 2, That is the respondent number 1 in this case. Okay.
In this appeal, Lordship.
Huh?
In this appeal, I'm appearing for respondent number 1 and 2, Lordship.
Till payment to the OP number 2. OP number 2. Till payment to.
I am OP number 5. Appellee is the OP number 5.
In that appeal.
Till payment full stop DD. The OP number 2 number. Till payment full stop. The Oriental Insurance Company Limited as OP number 5 and the New India Assurance Company Assurance Day. Oriental Insurance New India Assurance Company Limited were directed to pay the award in the ratio of 50:50. And I colon different 50:50 within 1 month from the date of the order, i.e. 11/8/2015. Agreed by the order, the New India Assurance Company has preferred this appeal, whereas the Oriental Insurance Company preferred MSC appeal number 21 of 2016, which has been disposed of by a coordinate bench of this court by order dated 21/5/2015.
21/5/2019.
Oh, 21/5/2019.
And the awarded amount was reduced from rupees 50 lakhs to rupees 19,24,840.
The award was reduced from rupees 50 lakhs to
50 lakh 960
50 lakhs 962
rupees 19 lakhs
24,840. And the respondent number 1, 2, and 3, no? And both the insurers, i.e. Oriental Insurance Company Limited and the New India Assurance were directed to pay 50%.
50%.
50/50.
50% of rupees 19,24,840. It is submitted that this judgment and order covers this judgment and order relating to MAC 2021 or MAC 21 of 2016 covers it is submitted that this judgment order it is submitted that the present appeal is a covered case in relation to the MSc appeal number 21 of 2016. Correct? Correct? Yes. Thereby, the present appellant is directed to pay the remaining 50%.
The remaining 50% of rupees
50% of
rupees
19,24,840 to the
along with 6% interest.
Respondent number 1 along with 6% interest from the date of filing of the
claim
6% interest per annum from the date of filing of the claim petition to the date of this order.
To the claimants, Lordship.
Till final payment, Lordship.
To the claimants, okay. To the claimants.
Claimant
or-
respondent.
No, to the claimant respondent number 1, 2. What about 3?
3 is the
3 is the mother, Lordship.
Lordship.
I'm appearing only for 1 and 2.
As per the share given by the lower court judgment, she will entitle Lordship.
lower court shall be entitled.
Yes, yes.
So 1, 2, and 3,
1, 2, and 3, but I'm appearing for only for 1 and 2.
1 and
That
2.
may be referred. 3, I'm not appearing.
No, no, you have it. You have
No,
not
no, I'm not appearing. I'm not appearing.
Why?
3 is the 3 is mother lordship.
1, 2, and 3 then.
No, no, no. I'm appearing only for 1 and 2. I don't have any connection with 3.
Her share will be intact, Lordship. As per
Her
the
share will
law
be
concession.
intact. Yeah. In the other insurance also her share is intact.
In the other appeal, you have appeared?
No, no.
No, no.
Other appeal also.
I have appeared only for 1 and 2 lordship.
4, 5, 6, 7, and 8 are not necessary parties. Their names have been struck off.
Lordship.
Yeah.
I have to pass an order for 3 also. Though you have not represented 3, I have to pass an order for 3 also.
Lordship.
3 lordship.
1, 2, and 3, yes.
But I'm not appearing. I'm
I understand, but
Yes.
I have to pass an order for 3 also.
3.
No.
No, I'm not appearing, but that cannot be because I'm appearing for only 1 and 2 lordship. I don't have any connection with.
Her share will be intact as per the law concession, Lordship. And Lordship, a statutory amount may be allowed to be withdrawn after disposing the appeal, Lordship. Statutory amount which was deposited by the appellant at the time of.
Not in this judgment. Not in this judgment.
In this judgment also, Lordship will find the statutory fees of rupees which is deposited by the appellant at the time of filing will be adjusted to the amount to be paid to the claimants.
Where?
Last paragraph.
Last page, page number 9. In MS April 21 of 2016.
1 and 2 liquidated here. The appellant is also the appellant is allowed to withdraw the statutory fee of rupees 25,000 deposited at the time of filing of the appeal, which after adjustment of the amount to be paid to the claimants.
Yeah.
Respondent number 1 and to the claimants.
Yes.
In terms of the above observation, this appeal stands disposed of.
Yes.
I think was. As per observation in the MAC appeal number 2223 of 2024, this highest stands disposed of.
Within a period of lordship, within a period of 1 month. Period may be given.
1 month, yes.
Within a period.
1 month?
Yes, lordship.
To the amount to be paid within a period of 1 month from the date of this order. Copy এটা দিছিলে যে জাজমেন্টৰ ৰিপৰ্টটো ল'ব লাগে। এইটো লাগিব। Yes.
Lordship, this appeal against conviction today, I think Lordship for consideration of bail Lordship. IA, there is IA Lordship. LCR also received Lordship.
Oh. Yes.
Main appeal was earlier made before Justice Striker Sir. And I was.
Then to be placed before the.
No, what the last occasion, there is an order in IA, this short time, passed by your Lordship, this short time for their argument Lordship. I find that order Lordship in the month of April. This order Lordship passed by your Lordship in the IA Lordship.
এইটো absent পাওঁতে দিছে নেকি? বুজি পোৱা নাই। Is Ahmed is present for the appellate, learner additional PP, Mr. DP Goswami has submitted for time to go through the LCR.
LCR.
List the matter on 39 May.
Lordship, because he is in jail, Lordship, otherwise he is in jail, or else already received, Lordship.
29 May, 10 years
29 May, that is why,
No.
as he is in jail.
Before,
the reason-
Lordship, before, Lordship, 2 or 3 days earlier, Lordship.
How come I got it? 27 May.
My lord, in this particular case, as per the order of the honorable court, on the last, they provided the copy, but this copy is also incomplete. And if lordship kindly peruse, they have provided, this is a blank, page number 15. I have requested my learned friend to kindly provide what are your within knowledge and what are records, but till date.
Only affidavit paragraph, nothing else.
Okay, provide the
Yes.
copy.
But-
Learned counsel, Mr.
LK Bora.
Elko Bora is present for the petitioner. Learned counsel, Mr.
D. Nandi.
D. Nandi is present for the respondent. Petitioner to provide legible.
Only affidavit.
Huh?
Only affidavit.
Legible copy of the affidavit
Yes,
to the respondent. Only sole respondent.
yes, I am the sole respondent.
This the matter after 2 weeks or 1 week?
After, let it be, because moment I get the affidavit, the complete
2 weeks,
case,
yes.
I will file my objection. Deep papers.
May it please, Your Lordship. My lord, there is an office note, my lord. Surveys upon respondent number 1 and 2, not complete, madam. So we'll take justice service, madam. One more.
Learned counsel, Mr. S. Das is present for the petitioner. And learned counsel, Mr.
M. Hussain Mala.
M. Hussain is present for the respondent number
326.
326. Service report on respondent number
1 and 2.
1 and 2 is awaited. Justice service is permitted.
Yes, ma'am.
It is
Date-
after 4 weeks.
Date, my lord, June, my lord.
Hmm?
Any date on June?
List down. Do not get it.
18. Highly obliged.
Most of it.
35.
May I please, Your Lordship. Lordship, if your lordship will take IN civil number 23759, your lordship.
359 years.
In this application, your lordship, we have filed this application for withdraw the 50% deposited amount, which has been already deposited before the registry of this honorable high court on 22/7/2024.
Yes, yes. Lordship, we have filed our objection to that, Lordship. First of all, Lordship, our appeal is based on the fact that there was violation of policy condition, Lordship, by the owner. And in their first ground of our objection is that in their application, they have not made the owner and driver party, Lordship. Only it is a half complete petition, Lordship. Owner and driver are not made party
in the claim petition.
In their IA, Lordship, the IA 2359. Only the insurance company is made party, Lordship. So how can that be, Lordship? This is an incomplete petition. That is our first ground, Lordship, of objection. And the trial court had given the right for pay and recovery, Lordship. If the owner is not there, Lordship, and we are paying in their application, from where we will recover? So, Lordship, first they have to amend their IA, Lordship. They have to make the owner and
amend the
driver
IA or
party
you
and
withdraw
send
it, you
notice
file
to
on
them.
fresh IA.
Lordship, in this case, appellants is insurance company. And
No,
in-
no. Pay and recovery. Owner is a necessary party.
Yes,
Lordship, then I will,
Huh? You'll withdraw or you'll amend it?
no, Lordship, I will file this
Learned
amendment
counsel, Mr.
SI Akan.
SI
Akan.
Akan has submitted for time to file an amended,
Prospectus.
to file an application. What?
If your lordship allowed to file amended cost title, I will.
Wait for adjournment.
Lordship,
You do whatever you want.
yes,
I will
Lordship,
give it to you
appropriate
adjournment.
application will file.
Learned counsel, Ms. R.D. Muzumdar is present for the insurer.
Obliged, Lordship. 4 weeks, Lordship. I will not be there. I'll be out
Oh,
of
yes,
station.
yes, yes. 4 weeks.
Much obliged.
May it please your lordship. In this matter, as per the last office note, the address is found to be incomplete. So the service is not complete. I may be allowed to take fresh steps on a corrected address.
Fresh steps.
Fresh steps, your lordship. The address,
Learned Council, Mr.
C. Gogoi, your lordship.
C. Gogoi is present for the applicant. Whatever, or for all the respondents.
There's
or
just one respondent.
And has submitted that he may take fresh steps to issue notice to the respondents.
Yes, on the correct, because the address is found, address is not complete. It's
As
not
the
proper.
address is not complete, first off, the appellant may take fresh steps to issue notice to the respondent in his correct address, returnable within 4 weeks.
Obliged.
The lordship service has been complete and LCR also received, your lord.
I'm appealing for all sole respondent. All the respondents, 1, 2, 3. All the respondents. Both the parties are represented today. Service is complete. LCR is received. Please this matter for hearing or admission.
Yes, hearing, your
Hearing.
lordship, yes.
Already admitted.
Admitted, lordship. Lordship, date may
This
be
is matter
fixed.
for,
A date may be fixed, your lordship, in the month of July after vacation. Much obliged.
Obliged, lordship.
The matter is ready for hearing, lordship. LCR is received.
Both the parties are represented. LCR is received. List this matter for hearing in its usual course. In its usual course, 25.
Obliged. May I please, your lord?
Yes, yes.
My lord, the sole respondent died in this matter, my lord. And in this connection, I have filed 3 interlocutory applications. One is for condonation of delay in preparing the substitution petition and setting aside abatement, and for substitution of the legal heirs. So notice may go, my lord.
Yes.
Uh,
This will have to go
Well,
in 2 at least.
in IS civil number 1101 of 2025. This is the condonation petition.
Yes. এইটো এইটোতে লিখি দিবা হা বাকি কিটা নালাগে IA 1101 2025 applicant is represented by Learned Counsel Mr.
TU Laskar.
TU Laskar. Applicant may take steps to issue notice to the respondents to opposite parties returnable within 4 weeks.
4 weeks.
List accordingly.
Obliged.
Item 41.
May I appeal to the lordship? This IA is for continuation of delay of 29 days in preferring MSc appeal, lordship. We are the insurance company, lordship. There's 29 days delay.
29, whatever you'll have to issue notice.
Lordship, notice will go, lordship, 4 weeks,
the
lordship.
Learned Counsel Mr.
PJ Burman. PJ Burman.
PJ Burman is present for the applicant. Poster applicant to take steps to issue notice to the respondent. One respondent.
Respondent, I have to see, lordship. Respondent 1, 2.
Respondents.
Respondent 4 respondents. lordship.
Respondents returnable within 4 weeks, list accordingly. 4 weeks?
4 weeks, lordship. Obliged.
Lordship, this is a delay condonation petition of 50 days, Lordship. Notice may be issued.
Learned Counsel Mr. AJ Soki is present for the appellants. Poster appellant to take steps to issue notice to the respondent returnable within 4 weeks, list accordingly.
Item 43.
I please, your lordship. My lord, I have for conducting the delay of 159 days.
Okay.
in filing the.
Learned Counsel Mr. F.A. Ahmed is, F.A. Ahmed?
Yes, I am.
S.A.
Yes.
Ahmed is present for the applicant. Poster applicant to take steps to issue notice to the respondent, one respondent.
1 to 3.
Respondents returnable within 4 weeks, list accordingly.
Oblige.
It's a condonation application, but notice may be issued.
Okay, learned counsel, Mr. A Ganguly, technically लिखी हुआ बाकी के
I for condonation of delay.
learned counsel, Mr. L K Bora,
Yes,
okay, order.
possibly.
Delay 55 days.
Learned counsel, Mr.
KK Bhatt.
A K Bhatta, okay, order.
Same order, notice, go to
Learned counsel, Mr.
Yes, I can.
S I Akan, same order.
Sole res-
Sole respondent, single respondent.
so oblige.
My pleasure, Lordship. Here delay is only 5 days, Your Lordship. Say MSC.
You want.
Lordship, it may be admitted, Your Lordship, for hearing and negated, Lordship. I will take step, Lordship. They can pay for the 50% deposit.
We will not raise objection, no? 5 days delay, will you raise?
5 days delay,
objection?
Lordship. Unnecessary to delay the case, Lordship. After again, issue the notice. But they will not prejudice, Lordship. They can pay for the deposit also. I will, at the time of admission, we can
Learned
deposit.
counsel, Mr.
PJ Burman, Lordship.
PJ Burman is present for the applicant, National Insurance Company,
Yes, yes.
who has filed this application under section 5 of the
Five.
Limitation Act 1963 with prayer for condonation of delay of 5 days in preparing the connected appeal. Post of the applicant is aggrieved by the judgment and order dated 30/12/2024, passed by the learned member MSCT Dhubri in MSC case number 195 of 2012. It is submitted, a delay was unintentional. The delay was owing to the formalities that had to be undertaken. Undertaken by the insurance company.
Yes, sir.
Full stop. The learned, the applicant. I considered the submissions of the learned counsel for the applicant. Full stop. Sufficient grounds have been shown. It appears that delay was not intentional. For the interest of justice, delay of 5 days is hereby condoned, restricted to restore the connected appeal. In terms of the above observation, application, I stands disposed of.
May it please the Lordship, we have filed this IF for condoning the delay of 25 days in filing the appeal.
Learned counsel, Miss
M.
M.
Saitya, Lordship.
is present. How many days?
25 days, Lordship.
Respondent, how many respondent?
Four
Respondent,
respondents,
huh?
Lordship.
Yeah, আগৰ নিচিনা order কৰি দিলে।
4 respondents.
A to skip কৰি আগৰ order. Yes.
Oblige, Lordship.
Huh? No. Issue notice. Issue notice. A last order to skip কৰি আগৰ যোনবোৰ order আছে continuous.
May I prove, no? Here there is a delay of 69 days.
Learned counsel, Mr.
A Bhattacharya.
A Bhattacharya is present, বাকিখিনি একে।
Steps by only one, by only registered post.
Returnable within, you can take usual process.
No, actually there are 6
Okay,
respondents. So
To take
first,
steps returnable within by usual process as well as by registered post.
no, I wanted to take only by registered post.
Registered post, আচ্ছা usual process নালাগে, registered post দিলে। Usual process to কাটি দিবা।
Problem.
Last item, but very short.
Last but not the least.
Lordship, issue, well, to be very honest, this is ultimately, Lordship, it is a case for remand. What happened, my lord? Accident took place on 17th of July 2009. Claim application was filed for an amount of rupees 4 lakhs.
17 July 2009.
2009. Now in 2025, Lordship. That claim amount claimed was 4 lakhs and award granted was 5,000. The thing is that, Lordship, what happened? We have annexed all the order sheets. Lordship will kindly come to entire order sheets has been annexed, my lord. Lordship, kindly come to page 24. Lordship has got it, my lord.
Page 24.
Page 24 of the appeal memo. Annexure 4. This is the type copy.
Yes.
On 27th of October 2009, that was registered, notice issued for service report was fixed on 21/4/10. On 21/4/10, claimant represented OP number 1 and 2 have filed WS jointly. Next date was fixed on 22nd of September 2010 for documents and issues. On 22nd of September, ultimately claimant represented, issues were framed. Next, on the next date, claimant submitted evidence of 3 PW. So 3 PWs have been filed. Next date was fixed on 10th of August 2011 for cross-examination of PWs. On that date, on 10th of 8th, the petition on behalf of the claimant was filed seeking time, and that was allowed. The date was fixed on 14th of 12th, 2011. On 14th of 12th, nobody represented, madam. Then the case was fixed on 19/5/2012. On 19/5/2012,
Nobody was
claimant, OPs were present, claimant was absent. What happened in the meantime? There was a wrong entry. In the delay condonation application also, it was stated that the engaged counsel, conducting counsel, there was a, at that time, there was no e-courts and other facilities. So there, while posting the date in his diary, there was a wrong entry. Accordingly, he could not follow up the matter. Ultimately, it was decided, and Lordship will kindly see the judgment on 1st of August, award of 5,000 granted. That impugned order, Lordship will find at page 29.
What happens when the claimant doesn't turn up? You cannot dismiss the case, MSCT case, because Justice Ansari's judgment is
Yes,
there.
yes.
Cannot dismiss, and then you cannot file the case.
Yes.
So what the little bit of amount award was given?
Only 5 lakhs. Ultimately, all the issues, while deciding, issues were decided in favor of the claimant. It was not the case. Anything came to the contrary. In fact, Lordship will see the record. If your Lordship takes up the record, is there, my Lord. I have perused the record. Lordship will kindly come see page 22, page 22 of the records. There is a LCR is there, my Lord. Page number 22.
Page number 22, yes.
That is a discharge certificate from GNRC. Admittedly, from 17/7/2009, Lordship will see till 28th of July 2009, for 12 days, the claimant was admitted and he had head injury. Yes, my lord, that is that those documents, all the exhibits, the tribunal has found that, although Lordship, prior to that, Lordship will kindly turn to, Lordship will kindly turn to page 27 of the records. Internal page 27, sorry. That is the deposition of PW1. It is in the record.
Page 27, yes.
Yes. There, Lordship will see there is a statement has made that 89 exhibits are there in total, including the accident information report. But those documents, that exhibits, are not on record. I searched the records entirely. What happened? Because normally with the evidence, we always submit the copies.
Yes, yes.
Either in original or it is original exhibit. Lordship, then I have seen the second file in file B at page 5, the second pair, there is a flag, file A, file B. File B contains the daily order sheets and petitions and all, the petitions basically. Page number 5 of file B.
Yes, page number 5 of file B.
There, while submitting filing the evidence, down below, it was written that documents shall be submitted on the date of evidence. Lordship will kindly take note of that, my lord. Page number 5 of file B.
Yes,
Down below, Lordship will kindly see,
yes,
documents shall be signed.
yes.
That, and it was allowed by, it is presumed, my lord, that court has, learned tribunal has allowed that. Accordingly, on the date, it was supposed to be placed, but due to wrong entry, those documents could not brought on record. But while dealing with this method, the court has, in any manner, my lord, both the issues, two issues were framed. Those issues are whether the claimant Gopal Chandra Deka sustained injuries in the alleged road accident dated 17/7/2009 involving vehicle number WB72B2632, and whether the said accident took place due to rash and negligent driving of the offending vehicle, whether the claimant is entitled to receive any compensation, and if yes, to what extent and by whom against the opposite parties, the said compensation amount will be payable. Taking all these two issues together, the court has found that accident took place, that the claimant sustained injury, and a 5,000 compensation was paid. Lordship, at this stage, my respectful submission is that since the incident is of 2009, remanding the matter again to adduce evidence will take another time, because
4-5 years.
4-5 years in either appeal. If Lordship being sitting as a first appellate court, taking judicial notice of the fact that the claimant was admitted in the GNRC hospital at that period of time for a period of 12 days, that is on record, and that has been taken into consideration by the learned trial court, learned tribunal. So if that amount is enhanced, my lord, I am not saying, my lord, 4 lakhs we have to justify, but if Lordship gives a reasonable amount, then perhaps, my lord, my learned colleague will also not dispute to that, because otherwise, if they have not filed any appeal, so they are not saying, if they are disputing, my lord, they have not, had it been their case, that my vehicle is not in the accident, they would have come out an appeal.
Actually, what happened, madam, I will tell you. Amount which ordered by the court, tribunal, we are agree, we have paid it. So there is no need. First submission will not see it. At the time of incident, the person was 65 years old. And by this time, 50 years passed. So now, he is about 80 years. Whether he is surviving or not, my landlord has not said anything. Maybe may survive, may not survive. And documents, which submitted in the court below, tribunal below, those are not exhibited. Mere submission of a document in the court or tribunal, Lordship knows what is the fact of that document. Nothing, zero. That's because those are not exhibited. And there is no cross-examination. So, from that point of view, nothing. And when the court itself provision is there is no appeal is licensed. I am reading this book, motor vehicle act 88 Lordship amended 173 provision by
Amended is not what, this is not a new, this is 2017. It was amended in the year 2018, I think.
19.
19.
No, earlier it was not, that is there, earlier it was 10,000. Now it is 1 lakh. Only this much. And provision I am reading, your Lordship, no appeal shall lie against any award of claim.
6 section
173.
173. Achha.
Very good.
Now appeal is not under 173, I think.
It's not,
You
earlier,
recommended that?
but they are finally on 23. On that provision, yes,
Yes.
their appeal is Miller and appeal under section 173 of the Motor Vehicles Act 1988. And this is the Miller Motor
This is grievous injury or what type of injury?
Grievous is head injury.
My understanding is Miller only Miller very it is very simple injury. They were Miller driving a scooter motorcycle Miller and they hit him. And his case was and his case was reasoning is me Miller and then in that case I was acquitted. So Miller provision Miller you must can see if I am not wrong Miller. Here 173 provision Miller subsection 2 Miller. As in
173 subsection 2. Why will appeal not lie?
lie against any award of a claim tribunal if the amount is in dispute in the appeal is less than Miller, that is probably 10,000.
Okay, okay. It is less than 10,000.
Yes, there is no, it is a 4,000 or 5,000, so there is no appeal lies.
Less than 10,000. No appeal will lie.
Right.
Now, where will the person go, aggrieved person go with? Because that is perhaps for the insurance, had the insurance, there been insurance, the insurance.
No appeal. No appeal. Amount disputed is 5,000 only.
Only, yes.
When was the MB Act amended?
No, this is
2018, 19.
2019 amended.
It was
but
amended
before
on-
it is now 1 lakh. And earlier it was Miller 10,000. So it is 5,000. So appeal no appeal.
No appeal shall lie against the award of.
And they have filed the Miller claim
If the
petition
amount
without,
dispute is
they have
less
form
than
54
1
Miller.
lakh asle 10 lakh.
That is not there. So without form 54, how the Miller that claim can be accepted in that?
They have filed form 54.
No, on form 54 is requirement and
They have filed.
we have not received any communication in our.
I think I saw somewhere, I don't know.
Anyway, Miller, first is my submission, Miller.
We supposed to.
Yes.
Yes, that is what I'm saying, my lord. The bar is subsection 2 will not apply in a case where the claimant seeks enhancement. If the insurance, if award is passed, I am the insurance company. The vehicle had duly insured. In that case, if it is less than 1 lakh, then insurance company files an appeal. Otherwise, if that interpretation is to be given, what is sought to be given by my learned colleague, the very definition, very purpose of MSCT Act will be defeated. Because ultimately,
Sorry, like, oh, yeah. എനിക്ക് AC ରୁ ସରିଲେ ସବୁ ସରିଲେ where an appeal is filed challenging the quantum of compensation irrespective of who files the appeal. The
Provided
appropriate
that no
course of
appeal-
the High Court is to examine the facts by applying the relevant principles. Determine the just compensation.
because this is second proviso, first proviso and second
If
proviso.
compensation determined by it is higher than the compensation awarded by the. Oh, there is nothing. If you are praying for enhancement, then there will be an appeal. There's nothing to substantiate this. Is there any judgment?
I have to find out because this cannot be, my lord. That interpretation cannot be given to defeat the beneficial purpose of the act. Because if my understanding is that had the insurance, because assuming for a moment an insurance company is directed to pay 1 lakh or say 90,000, that bar will applicable only to the insurance company. That bar will not attract. Suppose Lordship will say, taking the other way round. Suppose let me please. Suppose claim application has been dismissed.
Cannot.
Claim application has been dismissed.
You cannot beat around the bush. You give me supporting authority.
No, Lordship will.
Give you one more day. We'll hear you one more.
No, I'm putting the question to myself. Lord, forget
No.
about 5,05,000. If it is dismissed,
No,
suppose
it has to be strongly substantiated with authorities.
I'll place that.
Yes, I'll give you adjournment. You place.
Okay. Lordship will fix the date as per Lordship convenience.
He has a point, but. So
But I'll,
yes, you can dispute his point.
yes, because otherwise, Lordship, just I am asking it to myself. If a MSc appeal is dismissed,
Asking here and there will not.
no, if MSc appeal is dismissed, then I have also instances where I have,
There, all those things we can also ask. No?
yes,
Third learned counsel, Mr.
T. Chakraborty.
T. Chakraborty for the appellant. Learned counsel, Mr. Who has submitted for time to place his argument on the maintainability of this appeal. Third learned counsel, Mr. A. Rashid for the insurer. Is the matter on?
Sitting partner, Milord.
No. This is a very teeny tiny matter. It will be disposed of. I'm not giving it the part.
Right.
But if I'm there, then I'll take it up. And
Right.
I'm very interested to know what he wants to submit.
Yes.
In fact, I'm very interested to know.
Well,
Google नहीं किया।